ask those who can to please have your cameras on, because we are on PBCJ. And certainly if your camera is off when you wish to make a remark, please put your camera on. But for those who can keep their cameras on, we would very much appreciate that. Thank you, Senator Scott Motley. Thank you. Thank you, Solicitor General. Thank you, MP Daly. Thank you, Senator Gale. Thank you so much, Senator Longmore. I know Minister Chuck said he would have his camera off for a while. MP Sibley's, are you there? Okay, so
I am on, but I will mute while I take a break.
Yes, we can handle it on and off, but we can't have a black screen, you know, constantly. All right.
Chair, I might have to take off my video at times.
Yes, yeah. Okay, so colleagues, I would like to make some brief remarks before we begin. We have come a far way from the time of the initial tabling of the bill to where we are now. We are by no means finished, but the speed at which we have been working underscores our commitment to destabilizing the issue of sexual harassment in the society. I must express my appreciation to the members of our society for their interest in the bill, because the interest is very high. Your interest speaks the urgent need for the operationalization of our legislation. As is customary, our work is being carried live on PBCJ, as I mentioned earlier, on cable and online. We resume our clause-by-clause review of the bill and the proposals made by the various stakeholders. And so today we pick up from clause 30. So at this point we will begin. I'm sorry, Ms. McCarthy, did we have any apologies? Do we have any apologies for absence?
Chair, we have one for lateness for Senator Campbell Rodriguez.
Okay, thank you so much. Ms. Grant, could you pick up now for us from clause 30? What we will do, we'll take it from clause 30 through to the end, and then we will go back to matters now that were unresolved for us to make those decisions. I have to emphasize that we have a deadline. I am hoping that we will be able to take the report to Parliament on the 7th of April. That's the deadline with which you are working to table our report. So we have, although we have done quite a bit of work, we still have some work to do. And I know that if we move expeditiously, we can achieve that deadline. Hello, Natalie, how are you? Ms. Campbell Rodriguez, how are you, Mrs. Campbell?
I am fine, thank you.
Fine. Very good. All right, thank you. So, Ms. Grant, could you proceed? Thank you.
Yes, Chair. Good afternoon, members. Good afternoon, everyone. All right, so we pick up from clause 30, which deals with the evidence before the tribunal. And just to say really that one suggestion was made, and that's the suggestion from the Ministry of Education, Youth and Information, that as it relates to the evidence being presented before the tribunal, that the civil standard be adopted. That's the only comment that was made.
Yes, Ms. Grant?
Minister, Chair?
Yes, please go ahead.
Could I just get a clarification on what the specifics are regarding the civil standard? Be reminded, please.
Go ahead, Ms. Grant.
So What the ministry mentioned was as it relates to how the evidence is presented. So in the criminal realm, it's beyond a reasonable doubt, but in the civil standard, it's on a balance of probabilities. So they just want to make that clear in terms of how it is to be presented. So it's not the criminal threshold that you will meet, but it is on a balance of probabilities as you present the evidence. So they felt that that wasn't clear in terms of how it's worded now.
Okay, all right, thank you.
Because I just turned on my camera.
Just a minute, Camera Rodriguez.
I wasn't saying anything. Sorry, let me mute.
Okay, thank you. All right, Ms. Grant, please proceed.
Well,
Before we move on, Chair, may I comment on the whether it's beyond reasonable doubt or balance of probability? I would really love to hear the views of the technocrats with regards to whether it should be on a balance of probability or be on a reasonable doubt, because this is a serious offense. I know it's civil, it's a civil matter, but notwithstanding that it's a civil matter, it's a matter that really, if one found guilty, you know, it goes to the heart of reputation and have a serious impact. I would love to hear the technocrats and even the Minister of Justice, if he is able to say something on this matter. I don't see the AG on, or the Solicitor General could even comment. I would love to hear the comments as to why we are going for a balance of probability vis-a-vis beyond reasonable doubt as it relates to this matter.
Thank you, Mr. Sibley. Minister Chuck, would you want to take this and then the Solicitor General?
I think Member Sibbles has brought up a very important point, because in many ways, should I say, a ruling that a person is guilty of sexual harassment is similar to a criminal offense. Although it may not be a criminal offense, it is an offense. And the criminal standard is on beyond reasonable doubt. And therefore, I don't know why that particular burden or standard should not be used. So I do agree with you, Member Sibbles, that, you know, it might make sense to use the standard of beyond reasonable doubt that are at least a high degree of probability that the person committed the offense. But merely on a balance of probability might be too low a standard. That's my view.
Thank you, Minister Chuck. Solicitor General.
Okay, so thank you, Chair. Right now, the bill does not indicate the standard, as far as I recall. So it is usually left to the ordinary understanding of what the standard would be, which is what I think Ms. Grant was explaining. As it relates to civil matters, the standard is balance of probabilities. I see that the committee is now saying that they think there should be a higher standard of proof in these matters. So what you need to consider is, if you're going to put the criminal standard, it means it's harder to prove the case. It means that the evidentiary rules are different. And we would have to build in a regime in the bill to accommodate that. So it's not that it cannot be done, but I'm just saying that it's not a very simple matter. I know, for instance, in matters where you have, say, disciplinary proceedings where someone's livelihood is on the line, courts have ruled that the general and the ordinary balance of probabilities is not high enough, and there is almost a sort of hybrid sort of standard, so to speak. And this is why some of these bodies that hear matters like this, so for instance, the public service regulations where they establish a tribunal, all of those rules are actually codified. So it would be a lot more than what you have here in this bill. It would, because it's a more rigorous process. So it's not that it cannot be done, but if that is the way the committee wants to proceed, then we would have to make some adjustments to the bill to accommodate it.
Thank you, Solicitor General.
Sir? Minister?
Yes, please go ahead, Mr. Senior.
Yes, thank you very much. Minister,
Okay, go ahead, sorry.
I am very, very concerned in respect to making sure that whatever we are going to put in law will be able to stand up to strong scrutiny and also to be interpreted in the right and proper way. And I want to agree with Mr. Sibley's, is the person who spoke, that we need to make sure, the Solicitor General is saying that if we want to, but it's not if we want to, it's if it must go in order that we'll be able to have full clarity. I would love to hear that coming out of the committee instead of saying that if we want to.
Thank you, Denise. Mrs. Seeley Brown?
The camera's still off.
Please go ahead,
Thank you, Chair. Sorry. Chair, are we aware that it is the complainant who we are placing this burden on, the person who is bringing the complaint? I just want us to be clear on that we're lifting that burden, that standard, so that a complainant who is bringing this complaint before the tribunal is going to have to prove beyond reasonable doubt and not on a balance of probabilities that he or she has been harassed. I just want to put that out there.
Well, I'm sure that is not the intention, to put the burden on the complainant. Yes, Senator Longmore and then Senator Scott Martley.
Yeah, thank you, Chair. That's why I had tried to get the clarity, because I wasn't sure if it was my understanding. These matters are so subjective at times, and very often times not witnessed or very difficult to prove, and that's the nature of why the offense can be so damaging. And to put it where beyond a reasonable doubt, I think is a bit extreme and a bit onerous on the victim already to have to prove that level, and especially when it is appreciated as a civil offense. To put, in my interpretation, I'm not sure if I'm getting the legal ramifications or the legal pathways correct, but to now have a hybrid situation of criminal requirements for proof, or what would be more for a criminal offense, I think would be too onerous on the part of the victim, for us to go that route. Thank you.
Thank you, Senator Longmore. Senator Scott Martley.
Sure, I have to apologize because I was knocked off completely for a while. But the observation I would have made had I been able to at the time was that it clearly should be a civil standard. If you look at the legislation creates offenses which are criminalized, but it is only those offenses which are criminalized. But the structure and framework of the sexual harassment bill that we are debating is that it is a civil standard, and when the matter is deliberated, it is a civil remedy, which which the tribunal orders. So I can't see how a criminal standard could come into this at all. Those, respectfully, are my views.
Thank you, Senator Scott Marty. Senator Gail, you wanted to make a comment? Could you unmute?
Oh, sorry about that. So when the discussion started, I looked at clause 34. And that is the area that would provide the awards or the judgment. And as Ms. Aldred indicated, we would have to now change the fabric of the legislation. And in my mind, we would have to change that. I can accept the fact that, you know, we need to promote certain standards, but at this stage of the game, when we are seeking to raise the standard to that of a criminal level, where the burden of proof will be on the victim, it is going to be extremely difficult and might not inspire confidence in the legislation in the first instance when we seek to promote it at this high level. So I'm a little concerned. I would want and wish for it to remain treating with the civil approach, and at the time of review, having gone through a process of evaluation for a defined period, then we make a determination whether or not we need to explore a greater level of standard. That would be my submission, Chair.
Thank you, Senator. Okay, so Ms. Grant, could you just review and let us make a determination?
Well, Minister, based on the responses I have heard, it seems to me that most the responses are in favor of the civil standard being the standard that is used. That's what I have gotten. And even though it's not in the bill, but just to make sure that that is a decision of the committee. That's what I have, but I just want to make sure that that's a decision of the committee.
So I will ask if that's a decision of the committee, and if there are no objections raised, we will consider it so.
Minister,
yes,
before you go to, okay, can I, it's been some time, but why I'd raised the question or ask the technical people to see if they could look at it or to inform me. I vaguely recall in a matter that even though it was a civil matter, a decision was taken on the balance of probability. And right now, I'm not able to research or to get back to that particular case. But there was a matter where a balance of probability, it was a civil matter, and the court had allowed the appeal, saying that notwithstanding that it's a civil matter, the fact that the seriousness of the matter, just making a decision on the balance of probability was too low of a scale to make a decision. And that's why I had asked the technical, because I have not done the research but I can vaguely remember in a matter that was a concern of the court. And that's why I raised it. So, Chair, I would ask respectfully if there could be some research in the area before a decision is taken.
Thank you. Please, I will recognize Senator Campbell Rodriguez.
Thank you. My hand raising function is not working somehow, which is why I'm physically raising my hand. Just to weigh in on this matter, I'm also suggesting that it remains as such. We do not want to put any additional burden on a complainant who is potentially a victim. And so that's the reason for it. And I understand Member Sibley's point about there may be a case law that allows for this to be moved to a more criminal, penalty, but I don't think that matters. It is what us as a committee would prefer and see as the best thing for this particular bill. And as such, where you called for us to vote on whether or not we want it to remain as a civil matter, I'm just suggesting that we keep it at that. I don't think we need to research any further. If as committee members, we're standing by, majority of us are standing by that it should be a civil matter, not a criminal matter. That's just how I look at it, and as such, wanted to give my feedback accordingly.
All right, thank you, Senator Campbell Rodriguez. At this point, what I would say,
Chair,
yes,
through you.
yes, go ahead, Senator Longmore. Go
Thank
ahead.
you. Through you briefly. Perhaps also the circumstances. That hello. I don't know if you're there. Hello.
Yes, go ahead. Go ahead.
Sorry, I lost connection. Perhaps the circumstances that may be escalated would be dealt with other legislation like the Sexual Offences Act, etc., and more serious if the offense under harassment is that escalated. Perhaps another act would suffice. So I think we probably have a solution already. Thank you, Chair.
Thank you, Senator Longmore. All right, so at this point, what I would, it would appear that there is general agreement that it remains. However, MP Sibley's is asking for some research to be done, and I think that we could ask technical persons to do so. But
I would want to join with him as well, Minister. Not that I would not want to go with what is happening now, but to make sure, just for my own clarity in my head, because I'm not feeling it. So I would really love to join in some more research being done in order that we will be getting a more clearer understanding in going forward.
Thank you, MP Daly. And I would like to ask the Solicitor General to just again clarify so that it's very clear as to the difference in opinion here and what we're asking for in relation to reviewing that particular position. Please go ahead, Solicitor General.
Thank you, Chair. And in fact, I just raised my hand to speak because I would have wanted to understand what exactly are we going to research, because as I tried to explain before, we don't put the standard of proof in because with civil matters, the standard of proof is clear. It's clear by a case law. If you wanted, however, to elevate the standard, that is when you would have had to then do an amendment to what you currently have to indicate the standard that you want. And what I said was, it's not that it cannot be done, but would you really want to do it? And Mrs. Seeley Brown then put it into context about who would now be bearing who would basically have the consequence of this new standard. And it would be the person who has to prove. And who is that person who has to prove? It's the person bringing the charge, who sometimes, so in a way, this new standard really could in a way undo some of your policy. It could undo the effect of allowing persons who do not always have the backative, so to speak, to try to get their matter heard. it is not a criminal offense, so it is not a criminal standard. I did raise a point, though, that we do have cases or matters, types of matters, where there is somewhat of a hybrid standard. And again, that is done in situations, for instance, I am aware, and I'm aware of case law that explains this, in situations where, as I said before, persons are on disciplinary charges and likely to lose their livelihood. When you're going to be fired, that's your livelihood. That's how you feed your family. Things like that. It's done, and they have a hybrid standard because, again, you want to help to protect that person. I think you'd have to go back to the policy intent of this legislation. And I know that there are two persons in a matter. You'll have a complainant, and you'll have the other side. The issue is, what are you trying to achieve in changing the standard? Who are you trying to protect if you decide to change the standard from the ordinary civil standard? And that I'm not clear on. As it relates to the research, I'm not sure what we would be researching, whether it is that we want to see if in other jurisdictions these types of matters are treated using a criminal standard. Is that the research that you'd want?
That's what I'm saying. Yeah, exactly so. Exactly
And
so.
how it's treated in other jurisdictions.
You're right. And I want also, Minister, really, I want us to use the language, not to say who we are trying to protect. We want to protect both the accused and the victim to make sure that fair play, because while it might be just a civil matter or it's not a criminal offense, but you do not understand that when people are being accused and they are wrongfully accused, it don't just stop at the job. It stops at the family. It don't have any end. So whatever we are doing, we must be able to do it and feel justifiable that it is something that will be able to make our laws that we put in place be very effective.
Yeah. Okay, if I could just make a quick response, Chair.
Yes, please.
Sorry, Senator. It's just a very quick response to say, yes, we can advise the committee what standard is applicable in other jurisdictions, but just to note, whether you use a civil or a criminal standard, the case law, the courts have a responsibility to ensure that there's fairness on all sides. You don't have a fair trial only when you use a criminal standard. You have fairness even at the civil standard. And again, we would have to also be careful because you don't want to use a standard that is completely inappropriate to address a situation, which is why I said you would look at factors such as would it benefit one side more than the other? I'm just saying that for you to vary the normal procedure, you really should have good grounds and there should be a really good basis for this. But we can do that research and advise the committee at maybe the next meeting about the standard that is used in other jurisdictions.
Thank you, SG. MP Sibley, I saw your hand up. MP Sibley, I see also Senator Longmore's hand.
Yeah, thank you, Chair.
We'll take MP Sibley, then Senator Longmore. Thank you.
No, Chair, I will yield to Senator Longmore.
Okay, thank you, Senator Longmore.
Thank you, Chair. Thank you, MP Simbers. Just making reference to clause 39 and reminding us that we have protection against false accusations, where there is provisions for a person not making a false complaint, and that carries significant weight. So, whilst I am very cognizant of the potential for abuse, I still have to recognize the burden on the victim and keeping it as amicable to them as possible. Thank you, Chair.
Thank you so much. Go ahead, MP Sibley.
I believe my concern was answered by the Solicitor General. In no way I would want a balance to reach a criminal burden. I'm not saying that any at all. I just want to make sure that we looked at it in a way to see what obtains. And once we see what obtains, then we can make an informed decision. Thank you.
And through you, Chair, I for one got a nice little lesson in legalities there. Thank you. Appreciate it.
Thank you, MP Sibley. Thank you, Senator Longmore. I, as chair, would like to say let's be guided by the technical team and, proceed, as I get the feeling that most members of the committee would want to stick with what's recommended here. However, it does not rule out the research being done so that MP Sibley and MP Daly can be informed in relation to how they feel about the matter. All right, so you have got that, Ms. Grant?
Yes, Minister, I have.
All right, so we can proceed.
Clause 31, which deals with attendance at hearing. The only suggestion made there is really as it relates to a missing punctuation mark. Well, a punctuation mark that should not be there, I should say. And that is the Ministry of Tourism, delete the full stop after the word may at 31.3. Right, so there is a full stop. You see the tribunal may and the full stop. So this is just delete the full stop after the word may. And that takes us, no other suggestions were made. It takes us on then to 32, clauses 32 and 33, for which no suggestions were made from any of the three matrices. So that would then take us to clause 34. So it would mean then that clauses, unless the members have no further comments, that clauses 31, 32, and 33 would remain unchanged.
Sure, I think we are all in agreement, so you can proceed.
Very well. So that takes us then to clause 34, the award of the tribunal. The comments from Matrix 1, the Ministry of Tourism noted that in relation to 34B, clause 34B, subparagraph 2, it says it does not outline the bases on which damages arising for sexual harassment would be assessed. They also indicated that the payment, whether the payment of compensation would be appropriate, and in what circumstances would a direction to employ a prospective worker be appropriate. 34(1)(b)(5), they queried on how one could vary the termination of a contract or an agreement, and made the point as well that the bill does not expressly seek to cover disclosure made in the public domain, nor does it state whether any such disclosure falls under the sub judice rule, which essentially means matters that are already in the throes before the tribunal. How do we treat with disclosure as it relates to those matters? And a moment here. Continuing on, Ministry of Labor and Social Security noted that the provision for dismissal and certain other actions in the bill and the inclusion of provisions that those things need to be looked at to prevent double awards for the same types of actions. And those are the comments as it relates to Matrix 1. I'll go down to Matrix 2, where the private sector...
Do you want us to... I saw Mrs. Coburn Robinson's hand up. She may want to comment on the matters that you just raised.
Thank you, Chair. I wanted to take us back to 31, because I noted that there was a recommendation from remote kind of participation. And I'm thinking that, let me just read, it says, and that's from JTEC, Jamaica Tertiary Education Commission. The proposal is that there be consideration and language to allow persons, complainant or any other person, to attend and give testimony remotely. And it says this could be considered for levels, for proceedings at the levels of the employer or institution. So I'm thinking, in light of the fact that we have COVID-19 as our contextual reality, new normal, this could be something we could look at to see whether or not the committee would consider accepting this recommendation. Thank you, Chair.
Oh, any comments in relation to that? Go ahead, SG.
Thank you, Chair. I wholeheartedly support virtual meetings, and in fact, I want to again commend you, Minister, and your committee for agreeing to have this sort of venue as well, this virtual space. But as it relates to a hearing for the tribunal, I really do think it should be left to the tribunal when they're doing their rules to make that kind of provision, where they can then specify on a case-by-case circumstance how they deal with whether they have persons in front of them physically, whether they have them virtually, because a number of things can come into play. You do have some persons that do not have the capability or capacity to be able to interface in the way we are interfacing now. And you wouldn't want to disenfranchise anyone. So I think it would be best if the tribunal itself, when they are going to have their sittings, when they make their rules, that they take these matters into consideration. But nothing in the bill precludes it. And that's what to me would be important. If you had something that prevented it, then we would have needed to ensure that we take that out, or at least consider changing it. But I've looked back at the provision, nothing prevents it. Place and date of hearing can be in any format. Well, I don't know if Mrs. Seeley Brown has anything else to say in terms of the wording in the bill, but that's my interpretation of it.
Thank you, Solicitor General. Mrs. Robinson, you wanted to make a further comment? Your hand is up. Mrs. Robinson? Mrs. Seeley Brown, would you like to comment on this?
Not really, Chair. I agree with the sentiments expressed by the SG on this matter.
All right, thank you. All right, so yes, Mrs. Robinson, you wanted to make a comment? All right, your hand is down. Okay, so we will accept the recommendation or the comment made by the Solicitor General, and we will move on. Thank you. Ms. Grant?
Yes, Minister. Okay, so continuing on as it relates to the comments made to 34, we're on Matrix 2, where the Private Sector Organization of Jamaica recommended that a list of acts be specified. I guess that is as it relates to the award section. A list of acts be specified, such as a letter of apology, etc., and that there should be a cap of a total sum awarded by the tribunal, and they suggested 2 million or 2 years salary, whichever is greater. The UE Hugh Shearer Labor Studies noted that in 34B2 there is a passing mention or a nod, it's really a nod, to restorative justice, but there is no reference to mandated training of perpetrators re-behavior modification, where it is found that there is actual sexual harassment took place, and noted that there is no provision for that. And those are the suggestions in relation to 34.
Thank you, Ms. Grant. I invite comments at this point. Senator Gale?
Chair, you know, from my own observation, I looked at 34B3, and I had a particular concern in terms of a direction that the respondent should employ or re-employ the complainant. Now, in the event that this would have been a recruitment process where individuals would have been invited as applicants for a job. And in that regard, there would have been an allegation regarding the harassment. What this is suggesting is that the tribunal should direct for employment. But the concern that came to my mind is whether or not, in any case, that applicant would be the most suitable applicant. And you would now place it in the hands of the tribunal to make that determination. So it's a little gray area for me. And I would like some sort of feedback on that. In terms of 4, a direction that the respondent should pay to the complainant damages by way of compensation. And I make the assumption that the tribunal in this case would have the prerogative or the authority to make that determination. I have taken note where the PSOJ has suggested that there should be a cap on it. And I'm not particularly attracted to this notion that there should be a cap. I've taken note also that in another jurisdiction, well, another tribunal, the PSOJ would have sought to promote this cap. And it's a little concerning for me because I would want it to be left up to the directives of the tribunal to make that determination. And so I have a concern with that suggestion being made. So those would have been my 2 initial comments in regards to clause 34. Thanks, Chair.
Thank you, Senator Gale. Solicitor General, you wanted to make a comment? No? Okay.
You couldn't pull me, you couldn't give me some slacks.
I'm inviting comments here. So,
Chair,
yes,
I want to support Senator Gale. I want to support Senator Gale in his observation about the direction that the respondent should employ a person. I understand the circumstances under which like an offering, an inducement is made and so on. And so there's a basis for sexual harassment. If you don't sleep with me, you can't get this job and so on. But I share his view that it would be going too far for the tribunal to recommend employing this person without an evaluation being done of whether or not this person was competent or suitable for the employment in the first place. I don't think that that should be an option. I agree with with the whole issue of re-employment, however, and I've seen that, I've seen where that has happened, that after everything is over and the whole situation has been trashed out, people can actually function together in the workplace. Mm-hmm. But in terms of the tribunal determining whether a person should be employed, I'm fully supportive of Senator Gale.
Thank you.
Here, if I may just have another bite at the cherry.
Please go ahead. Go ahead.
Because the other thing that came to my mind is that we would be encouraging the possibility of an intolerable working relationship. If in this instance, there would have been allegations towards an employer and a tribunal was to force that employer to engage the prospective candidate, we're seeking by way of this legislation to promote an intolerable working relationship. And that employee is going to be exposed to further risk and maybe victimization.
Thank you, Senator Gale. So we are suggesting a change there. Mrs. Celia Brown or
Chair,
General, but yeah, go
Chair,
ahead.
if I may ask just a little direction here. In the tribunal's direction to employ or re-employ, would there be an avenue for the victim, for the employee, to request or deny? Or are we, I'm not clear, are we stating that the tribunal will give this directive irrespective of, it's an automatic directive? Or the employee may opt to not seek?
I understand where she's going. I understand where you're going, Senator Longbourn. And this specifically now has to deal with the re-employment.
Yes.
Because I've seen awards in the Industrial Disputes Tribunal that the employer must determine within a defined period.
Yes.
Whether or not the person can be re-employed or compensated.
Mm-hmm.
The only challenge I've had with an award like that is that it gives the authority on the employer and not the employee to make the determination whether or not the employee wishes to be re-employed or to be compensated.
Yeah.
And if the unjustifiable act was against the employee, then it's the employee that must have that desired wish to determine.
Yes.
Now, in this case, what we have to do is to separate how you treat with that prospective candidate who would have applied for a job and what the remedy ought to be, and how you treat with, on another hand, the question of re-employment, and give the employee the option to determine whether or not they would wish to be re-employed or to be compensated. Because at the end of the day, one of the things, again, you would seek to want to prevent is the creation of a further intolerable relationship because of the perceived act that may have been conducted.
But I also think, Chair, that
Chair,
I also think that if you look at Section 34, which deals with the award of a tribunal, you will find that it does offer a wide range of options that the tribunal can adopt. If you look at 34B, it sets out that they may find in favor of the complainant and make a determination which may include any one or more of the following awards. Now, I don't think that, as I said previously, I agree with Senator Gale about the employment, but I don't think that we need to overthink this kind of situation, because one of the things that we do when we are contemplating it is that we have to have confidence in the person, in the minister who is going to appoint the tribunal, that he's going to select persons who can make a determination as to which one is the appropriate remedy in this situation. And not only does it specify and guide the tribunal in what it can do, but it also says at 34C, makes such other award as may be appropriate in relation to the complainant. So I don't think you would find a situation where, having regard to the fact that one of the things which we are seeking to do is to prevent a toxic workplace, I find it really challenging to consider that a tribunal would choose that option in a situation where it would be clear that both persons could not function at all. So I think the range which is given at 34 is an acceptable is acceptable to meet most of the circumstances.
Thank you, Senator Scott Markley. Senator Gale, I'm going to ask you to just hold the chair for me. You give me about 10 minutes to deal with an urgent matter. And I will now recognize Mrs. Celia Brown.
Okay, Chair.
Thank you.
I thought you were just going to accept my submission, but anyhow. All right, Mrs. Celia Brown.
Yeah, thank you, Chair. I just wanted also to bring the committee's attention to subclause 2 of that same clause, which says that the tribunal may, in making an award under subsection 1B, take into consideration injury to the complainant's feelings or humiliation suffered by the complainant. So I think all of the factors that we are discussing here would be considered by the tribunal in making the appropriate award under subsection 1.
Chair, through you.
Thank you. Yes, Senator Longmore.
Yeah, I'm glad Mrs. Celia Brown went there, because I was actually not to change the context in which it's used, but perhaps to put a bit more technically appropriate language. Maybe I missed the session when we reviewed this clause. Take into consideration injury to the person, the complainant's feelings or humiliation. That terminology is a bit aged. I think a more broad-reaching depiction would be mental or emotional health of the complainant, rather than feelings or humiliation. When you use mental and emotional health, if someone is not able to concentrate, if their cognitive functions, if they're not able to focus at work, that necessarily is not covered by feelings or humiliation. The cognitive aspect of it would not. If we use mental or emotional health, it would be covered. It's a more broader application that would suffice to cover for the victim's consequences, I think.
The concern, Mrs. Celia Brown, you have your hand up? Yeah? You want to respond?
No, Chair. Sorry, I should have taken it off. Sorry.
What I would ask, just to clarify in my mind, because subsection 2 speaks to making the award in taking into consideration injury to the complainant's feeling or humiliation suffered by the complaint, which in my mind would have been expressed throughout the hearing for the tribunal to make that determination. Now, based on what you have indicated, could the tribunal make that determination in terms of the mental health?
Yeah, so basically what I'm bringing to the fore is the use of the term feelings and humiliations is a bit aged. It is like when legislation used to refer to the mentally ill as insane, and it had to be reviewed because the terminology does not connote or does not cover all that is possible. So feelings and humiliations, I think, kind of is limited in the mental impact or the emotional impact that the victim could suffer. And so there could be avenue for non-recognition of a consequence that the victim may have, but it is not covered under feelings or humiliation. So I'm just suggesting that the use of the words mental or emotional health, because that is more broad. It would cover feelings or humiliation, as well as especially what we would look at as the cognitive impact, the ability to focus, the ability to perform work, etc., because their cognition has been affected by this situation.
Chair, I think we should ask the technical team to frame it. One of the ways in which we can reference it is mental and emotional distress, which I think is a language that is often used in making awards under this heading.
Thank you, Senator. Thank you. Yes.
Thanks, Senator Scott Motley and Senator Longmore. So how do we treat with the concern that I would have raised in terms of the respondent should employ? And this is where I'd want to ask the technical team now, if whether or not they would have found acceptance to the concern, or could it be addressed in any way, given the concern that would have been expressed? It is at this point that I would have loved to see the hands being raised by the technical team.
I was hoping that Mrs. Seeley Brown would have jumped at the opportunity, but all of a sudden, Mrs. Seeley Brown is very reticent. I'm thinking about it. I mean, I fully understand and appreciate the point. And in fact, I was wondering how and when would this award be made? Meaning, would the tribunal even make the award if it wasn't requested? For instance, they hear the matter. Suppose is it that they would make the award even if the employee didn't ask for it? I started to go down a rabbit hole with myself. I'm not sure how it would come up. Granted, we have Wensbury's rules and decisions are supposed to be reasonable. Then following concern would be the employee asks for it, the employer is not in favor of it. Would the tribunal still make that award? And again, to me, a tribunal like this should be making awards where they know, yes, if something was done, if someone was wronged, they should be properly compensated. And I don't necessarily mean money, but, the wrong should be righted. But would you want to put someone in a workplace where they are not wanted at all? And even though you can always have rules to say they shouldn't be discriminated against, there should be no adverse actions or anything against them. I mean, it's a workplace. So I'm toying with the idea. I mean, one idea would be to just remove the words employ and just leave the option of reemployment. But to be honest, I really haven't done much research in this area. I don't know. I'm not sure why it was put in, because that's usually a basis for where we should start. Why was it put in? What was the rationale for putting in to employ the person? And I'm looking at it from a person where I also am involved in employing persons. And I really wouldn't want someone foisted on me if I really think that the person is not capable of doing the job, because you do have persons like that who don't have the capacity for the actual work. And so it could be that I have a bias here. But I would say that from the AGC perspective, perhaps we would be given a little opportunity to do a little research in this area, because I don't know what happens in other jurisdictions. And also I would try to see if we have any learning in our files to see why this was inserted as well.
Let me just, thank you for that response. Let me just go back to when you said you're going down the little rabbit hole by yourself. And whilst going down that little rabbit hole, you created an escape route when you indicated if the tribunal would make the award if it was being requested. Now, being the advocate, and if I was representing a victim and the instructions from the victim would indicate that they were desirous, I want that work. And I believe I should get that work no matter what. It puts me in a position, even though I would discourage the victim from taking the work, but the interest of the victim is that they want the work, and that would satisfy them as the award. Now, what we would have created is the opportunity to claim that award against what is transcribed in law, because this particular section could be referenced in making the submission to encourage the tribunal to make the award. And you're quite right, whether or not, what was the first intent for it to be there? Whether or not it would have been seen in another jurisdiction, we don't know. But the question is, if we remove it, if it would create any damage. And that is something that in doing the research, you may want to contemplate. But I see the harm in having it there. And that's why I raised the concern. Any other comment? Miss Grant, were we able to cover all the areas under the matrix for this particular one in our deliberations?
Chair, I noticed that 34.5. So in the same Roman numeral paragraph 5, where it says a direction that the termination of a contract or agreement should be varied to redress any loss or damage suffered by the complainant. One of the comments made by the Ministry of Tourism was, how would one vary the termination of a contract or an agreement? I didn't hear us address that.
Yeah, but this is not seeking in my mind to do that. But I see my good friend, Senator Sophia Fraser-Binns, holding up her hand firmly.
Thank you, Chairman, and good afternoon, members. Chairman, I don't know, because I did join the discussion a little late, so I'm not sure it was raised, but just following up on 31.3, where you raised some concern and the Solicitor General responded. I wondered whether there was any opportunity to explore the possibility of a re-employing the employee, but assigning in another area. 34.1B3.
Okay.
B3.
Yes,
right. Because I do understand the concern that both yourself and the Solicitor General have in terms of someone being foisted, the former employee being foisted upon the employer. And we have to also consider whether the relationship has broken down so badly that it would not make sense to continue. But at the same time, we must consider the request or the desire of the victim. And in striking that balance, I wondered whether there was any opportunity for a re-employment of the victim, but perhaps in a different area or a different division in the company where that takes place.
But just to say though that where the concern was not the area of re-employment, but in the area that speaks to should employ, where you would have applied for a job, being participant in an interview process, and there would have been the enticement of around sexual favors in order to get the job. And so your claim would have been, because of the allegations being presented, your claim would have been, notwithstanding what the tribunal would find, you believe you are deserving of that job.
Right. Thanks for that. Thanks for that clarification. And you know, it in my mind, I am convinced of the position of the Solgen, though she says she has to do her further research. But I wondered, Mr. Chairman, and again, maybe in the further research, we can get some guidance, because in any interview, there would have been certain criteria and certain things that the interview panel that is, would look at. And I wondered whether those, and I don't know if this is something to be placed in the law or it's going to be part of the rules or the regulations that govern the committee, the tribunal, but wouldn't those things form a part of their determination in making that decision that the person should be employed? Because you can't just say, as a matter of fact, the person should be employed, but you'd have to look to see whether the person would have satisfied certain criteria during the interview process for that person to even have an opportunity to be employed, notwithstanding the allegation of sexual harassment.
Noted.
Sorry, Chair, if I could just jump in before Mrs. Seeley Brown, just to respond to that. The problem we have is that we're not sure at what stage the person would have reached. Because, for instance, when you're employing someone, it doesn't always just be, it's not just always an interview and that's it. You can have different stages of a recruitment process. For instance, even in the chambers, the interview is the last step. It's not the first, it's the last step. So if something happened before that, where you didn't even get to an interview process, then for the tribunal to make this award, to me is a little challenging, because as I said, the problem is we don't even know at what stage of the recruitment process this claim would have been made. And of course, I'm sure everything would have halted at that time. So for the tribunal to then make this award, especially if it's at an early stage of the recruitment process, could be challenging. I mean, right now, even in government, after you even go through all the stages, there is still, especially in some, I think almost most of government, there is a
psychometric test?
No, not the psychometric. There's also another sort of review done to see if the person is appropriate, done by whether it's RPD or so, where they check things like
the background
checks, the criminal records and all of that. That isn't done early in the stage. It's done nearer to the end of the recruitment process. We don't even know if that would have been done before the tribunal would have made this award. So I think that is where I've been struggling with this provision. And not the whole provision, just the part that says
just
employed.
this part of it, right?
Yeah.
I see Mrs. Seeley Brown, and
Chairman.
I have Senator Longmore and Ms. Grant. Mrs. Seeley Brown.
Thank you, Chair. Actually, that provision was taken from the CARICOM draft that was used as one of the precedents for drafting the legislation. However, we know that from the other jurisdictions that we have checked, I'm not seeing that particular provision incorporated in their law. Those are for the ones that we've checked. Barbados, Guyana, Belize, those are the ones that I've had the chance to check. But I would just want to draw our attention, the committee's attention, Chair, to the Prevention of Discrimination Act of Guyana and Section 26 of this Act. One of the orders that can be made is an order directing the employer to redress the contravention, including an order if the employer and aggrieved person agree to reinstate such aggrieved person. So there must be some sort of a discussion and agreement before that person is reinstated.
So that is dealing with Mrs. Seeley
Yes,
Brown, the
employment.
reemployment.
Yes, but
aspect of
we've
it.
not seen anything which deals with the, as I said, it was a provision in the CARICOM model legislation, but it has not been adopted by the member states that we have here. We have reviewed. We haven't reviewed all of them. For the ones that we have reviewed, we have not seen that provision yet.
Mm-hmm. Senator Longmore, thank you, Mrs. Seeley Brown.
Thank you, Chair. I'm wondering if we're perhaps not, as Senator Scott Motley had maybe suggested earlier, that we may be overthinking it a bit, because I'm just thinking that the circumstances of potential employment, that every case is unique. Every situation, etc. There will be some deliberations and discussions within the tribunal, with the employer, with the employee, and I would imagine that all of that would then determine what the directive would be from the tribunal. So I don't know if we need to specifically legislate down to the T. Maybe it is in the regulations where we need to probably guide that we require that level of discussion and investigation as to the circumstances around the potential employment for the new employer. And I think I like that approach regarding the reemployment that Mrs. Seeley Brown just brought to our attention from that other legislation. I think it was Belize that she said. So I'm not sure if we're maybe overthinking, because I think the functions of the tribunal would include that type of discussion. Thank you.
Thank you. Ms. Grant?
Yes, Chair, just to say that Mrs. Seeley Brown said what I was going to say, because I drew from my batch of precedents here, the CARICOM model. The entire section was transported into Orville, and that is what we have there. Just to say, Chair, that, well, I haven't seen anything either in looking through other jurisdictions as to how they treat with employment. And so, yes, probably that's something that, as we do our further research, probably it might be something that needs to be taken out.
All right, so can we agree, therefore, that at the next meeting, the technical team can advise us in terms of how to treat with the matter of employ, whether or not we remove it, since notwithstanding the fact that it would have been prescribed under the CARICOM legislation, but not adopted by any other of the member states in their peculiar legislation, we can make a determination if we should follow suit, given the concerns that have been presented. And with respect to reemploy of the complainant, the tribunal, in making its award, given the authority to determine on its own merit the varying situations, they are allowed to make that determination. In essence, that would be my thinking in terms of an approach, but I would want the technical team to be in a position to represent it at the next meeting.
Through you, Chair, this is Nicole Wright from Legal Reform Department.
Hi, Nicole.
Hi, one of the senior assistant directors. In relation to the clause that you're speaking about, I had a thought, and perhaps we will do the research, but I was just thinking on my feet that looking at it from the standpoint of employing or re-employing, I was thinking from the employment perspective, perhaps, since there are issues in relation to, because the background to that would have been an interview, as you were pointing out. So I was thinking, could a direction be made perhaps for a re-interviewing process to take place if the respondent was minded to do so, and if the complainant would also want the ability to be re-interviewed if the direct employment would be an issue. I'm not too sure if that's something that could be looked at in terms of interviewing as opposed to a direct employment situation. Because interviews would have been had, there would have been various candidates, as you had pointed out. So I don't know if that would have been, if that could be a possible solution to the issue that has been raised.
Well, I have two concerns with that. The first concern is for a determination to be made as to what status, what stage of the process the alleged act would have taken place. Because it could have been where there would have been an expectation to be shortlisted in the first instance. If you ask for a re-interviewing, then does it mean that the re-interviewing takes place with that particular individual, or you have to re-interview and assess all? And then the third scenario may point us in another situation where if the tribunal was to award for a re-interviewing, would that create a reasonable expectation? And so these are matters, again, as we deliberate this particular point, that the technical team may want to consider. The varying scenarios that might apply in this particular one instance of an allegation. So I'm just throwing that out there. So, Ms. Grant?
Yes, sir.
Over to you to come back to us.
Sorry, and Chair, sorry, remember my suggestion read 34.2.
I was just going to ask about that. Was that agreed that we would insert that? Because while we were, well,
what was that again? Remind me.
Mental and emotional. Sorry, go ahead, Ms. Grant.
Sorry, mental and emotional distress in 34.2.
That was a term that Senator Scott Motley had indicated. She had given a different term in supporting of the argument. Senator Scott Motley, we're just asking if you had remembered.
No, I was suggesting that instead of mental and emotional health,
yes,
what could be contemplated is mental and emotional distress.
And I am in agreement with that, with distress being the, yes.
Yeah. Yes, I'm in agreement with that as well.
Committee members, can we go with that?
Yes, yeah,
I'm sorry, yeah. Chair, I missed that. What was agreed just now?
Mental and emotional distress.
Emotional distress.
Distress. All right, thanks. We can now move on. If there was no others, Ms. Grant, we can move on to 35.
Yes, Chair, we can move on to 35. Okay. Well, just two more.
Can I ask a question, Ms. Grant? In relation to 34.4, where it says that a respondent who fails to comply with an award of the tribunal commits an offense and shall on summary conviction in a parish court be liable to a fine not exceeding $1 million or so. That offense section. So the tribunal would have to set a time frame by which the award must be put in place. So, for example, the compensation must be paid by X date. Right. I'm asking because that one is a little bit unless there are some kind of specifications, because we don't have we don't have anything that guides the tribunal to say that the tribunal must give us a time frame. So I don't know how then you would be moving to failure to comply if you don't have something that regulates, sets out, whatever. So it's a question for you.
I take your point. Senator. I'm wondering though, as it relates to the time frame and upon expiration of the time frame, if maybe that would be something that they would be at liberty to look at in creating their own rules as opposed to us putting it in the legislation itself.
That is so, but they would have to get some guidance because there's a heavy penalty, a fine not exceeding $1 million or in default to imprisonment of 3 months. So I really would like some contemplation to be given to the best approach.
You see, it's two issues you have here, Senator Scott Motley. First of all, a failure to pay, having received a direction, and whether or not there was a defined period in which you must commit that payment.
Yes, that's what I'm saying.
So they could say that, yes, I have not paid, but there was no instructions given in the time frame to be paid. And are we to leave it to the tribunal to make that determination? Or
Chair, I really have not reflected on it, and that is why I am turning to the experts for some guidance as to how the best approach. I am concerned about the fact that this penalty is there and is substantial, and therefore I'm just putting it out that some consideration should be given to this. Mrs. Allred, Mrs. Allred, I'm calling on you as I've called on you many times in previous lives.
Soldier?
Yes, so it's definitely a rule of law. A criminal offense must be clear. It must be certain. Someone must be able to know what the offense is. And I'm a little concerned when I look at 34(1)(c), where it says make such other award. So the tribunal can make another award. We don't know what that award would be. But if you fail to comply with that award, it's an offense. And I'm not sure if that gives me the kind of certainty, if it complies with our general rule of law principles when it deals with offense creating provisions. It's something that we'll have to consider and take into account.
Yes, so Chair, can I therefore ask that some consideration be given to this section, because it does give me a great deal of concern.
Yes, and we will do so.
You know, I had 34C circled as one of my other concerns and just never remember to raise it. Because again, you know, to make other awards as may be appropriate in relation to the complaint somehow widens the parameters to which that tribunal may make an award. And would it be a situation where we set a prescribed limit to which the types of awards that can be made? Because if you leave it up to a tribunal to make appropriate award, then you also leave it up to those representing the matters to call for many things that are not prescribed if we leave it open. And that was one of my concerns. But if the team could
Chair,
review.
Chair, so I wasn't as concerned. The concern I have now is that we have now made it a criminal offense. we could sanction someone for not complying, because I can see where you may want to give the tribunal some amount of discretion in making an appropriate award, meaning, persons come before them, they hear what they have to say, they look at the circumstances. Sometimes you may have something that doesn't fit quite. It might be a round peg that you're trying to fit in a square hole. I could understand why you may want to have some flexibility. Of course, I still wasn't sure in my mind what we say an award, because an award doesn't have to be monetary.
Yeah.
It's not if we're talking about the ordinary meaning of the word, it doesn't have to be monetary. And I mean, I do think it is a little vague. It does give quite a bit of discretion to the tribunal. But my bigger concern is that we are making non-adherence a criminal penalty for something that we don't really know what it would be. So that is where we can try and just see if we can have a better idea of what is here and what is being proposed.
And maybe you can advise us whether or not there might have been similar treatment in a different legislation that is seeking to arrive at a similar objective.
Right. And I was so happy to see Nicole join in the discussion, because that's right up the legal reform department's alley.
All right.
ALLEY.
There you go. All right. So we can now move on to 35.
Yes, Chair. So with 35, no suggestions were made for 35 from either of the three matrices. So that takes us moving on then. 36, what we have there were no matrix 1, there were no useful suggestions. In matrices, in the other remaining matrices, no suggestions were made. So that takes us on to 37, unless
let's treat with 36 a little bit.
Okay, sir.
Because it's suggesting any person who is dissatisfied with any decision or award of the tribunal may appeal to the Supreme Court. In my mind, doesn't that create open season? Is there a particular, just to be dissatisfied on it, is that sufficient enough as a merit to appeal? Because you might be dissatisfied that the amount of money you received is not sufficient. Does that give rise to the right to an appeal?
I am in agreement with your concern, Senator Gill. It's a bit vague. Can any trivial thing, any dissatisfaction.
Technical team. Soldier, your hand is up.
It was to raise a different point, Chair.
Oh, I wish I could just put up your hand and just get a feedback on this one.
I think it's just, I don't know if maybe it's the language when we say dissatisfaction, but normally when you allow a right of appeal, especially from these types of matters, it's usually when there's an adverse decision. So it didn't go your way, you have the right to appeal. I know,
but this says any decision.
Me, I can understand and appreciate an adverse decision that I still believe I was wrong.
Yeah.
But it could be the question of compensation. It could be any of 34,
Any decision or award, any.
And I believe that there's something in it that would compel the individual to say, I'm still not satisfied. There's a course for an appeal. Make the appeal.
Right. So as I said,
and in making the appeal, those appealing would also be seeking to challenge the decision of the tribunal. But that's my concern.
Okay, just to point out though, even without a provision like this, a person has a right to approach, for instance, the court when a tribunal takes a decision. So it's a judicial review matter because they can ask the court to look at the process to see if all the admin justice rules applied, if there was a fair hearing, and all of that. So even if this isn't here, the only thing is, I guess the issue with this is that it's directing the court to consider the award itself. Normally with a judicial review matter, that wouldn't necessarily be a feature, but I guess here this has been included because it's dissatisfaction, not just with the decision, but the award, meaning the amount. But it's kind of difficult to lock persons out of the court process. But I see seasoned counsel Senator Scott Motley with her hand up, so I really have to defer.
I was really going to say that you have expressed the view so eloquently that I could take down my hand. But I don't think we can fetter the rights of an individual. As you have expressed, you know, they have this right. It's a fundamental right which they have if they are dissatisfied. And I don't think that we should consider attempting to fetter it at all. I think that would be unprecedented. And in any event, even if we don't include it, they would still have certain rights which are inherent.
Right. Let me just be clear that it was never my intention to create any blockage in terms of an appeal. I'm of the profound view that every individual has a right to an appeal. I'm just seeking clarification whether how it is written here, if it requires any peculiar catalyst that would give rise to the appeal, and not just where it is based on the dissatisfaction of the award. But I raise the question out of an abundance of seeking guidance. So, based on what the response has been, we can now move to part 7 and number 37.
37. Yes, Chair. So
sorry. Remember, I had my hand up on another issue. Yes, thank you, Chair.
This is because you took down the hand.
And got distracted as I easily do. I distract myself.
Sure. And I've recognized yours member daily.
But just to quickly point out, Mrs. Masado has reminded me that when the committee was looking at some earlier provisions, there was a reference to clause 34 and whether the awards were appropriate where children were involved. And I think the committee said they would consider it in a more detailed manner when they got to clause 34. Remember, there was discussion about children. So, for instance, in an institution, the bill does contemplate, for instance, someone in a school having the possibility of making a complaint. But then the issue was, were the awards that are set out in clause 34 applicable at all to children if they address that kind of situation where a child has made a complaint or someone on behalf of a child has made a complaint. So I'm just raising that, reminding you.
Chair, might I just say in relation to what the Solicitor General said, that was initially raised, but I'm wondering if it would still be a concern given that when we were looking at clause 25, what was decided was that reports made on behalf of children would be best treated in another legislation because it should be viewed strongly. And I recall the committee agreeing as well that there are at least 2 other pieces of legislation which they think would be better suited to deal with sexual harassment of children. So it was initially mentioned, that is true, but I'm wondering if it's still a concern given what was decided as it relates to clause 25.
And we had a lengthy discussion at the last sitting around that.
Chairman. Chairman.
Yes,
Chairman.
Member Daly.
Yes, I'm just going to ask if you could excuse me for a few minutes because I will be off on another meeting.
I see how you're moving. I would caution, but go ahead when you return.
Thank you so much, Chairman.
Right. Mrs. Seeley Brown.
Thank you, Chair. To the point that was just raised by Ms. Grant, I thought I thought the decision was made to treat it in relation to children. The decision was made to treat it as an offense, a criminal offense of sexual grooming under the Sexual Offences Act, and therefore we would not deal with children in this legislation. Well, that was my understanding of where the discussion went at our last meeting. So I'm not sure. I'm not sure if I'm agreeing totally with what was said.
Ms. Grant,
Okay.
you recall that?
No, well, just to clear up then, Chair, because what we were asking for is just reminding the committee that there had been a discussion about looking at what, if any, awards could be made. If this legislation is not going to deal with children, then there should be something, there would need to be an amendment. Because remember, you have provisions relating to schools.
Yes.
You have provisions in relation to schools.
It speaks to institutions.
So if we are excluding children from the remit of this law completely, because I thought what I understood from that legislation is, the discussion is, if it were elevated, if the issue is a criminal one, then it would fall under another law. But I've looked at what sexual grooming is, and sexual grooming is not quite what I think some people were saying it is. But I can understand if it is raised to a criminal standard or it falls under the Sexual Offences Act, then fine, it wouldn't fall under this remit. I'm just saying, though, if the decision has been taken that children are not to be addressed in this law at all, then changes have to be made. It should be made clear, because as it relates to schools, now I can understand it in a school situation, you can have, say, a teacher and the principal or whatever, but then you would need to make it clear that it doesn't apply to persons under 18. So that decision has not been taken as far as I recall. And that decision would need to be taken if that is where the committee is going.
Senator Scott Motley and then Mrs. Seeley Brown.
Well, Chair, I think I was the one who started that conversation by looking at the definition of sexual harassment and raising the question as to whether a child was capable of welcoming an advance. Because the definition was that it's an unwelcome, I'm trying to find it now. The sexual harassment means the making of an unwelcome sexual advance towards a person by another person. It goes on to say the circumstances. It suggests if you're making it applicable to a child, then my view is that you would have to consider whether you can use the word unwelcome, because we don't want to do anything that communicates that there are circumstances in which a child could welcome an advance. That was my concern and why I think we started that discussion. So I'm appealing to the technical staff to guide me on it. But you have to know what signals you are sending it is true that if we are going to say criminalize it, we could make an amendment to the Sexual Offences Act to broaden it, or broaden the to do a special definition in relation to children. Could we solve jail? Or something like that. But we have to consider whether or not we would be sending a signal that a child, it can be placed in the position of welcoming and advance. And to me, it would be contrary to all the other pieces of legislation that we have about children's capacity to consent.
And I remember you raising that the last time. We have Senator Longmore and Mrs. Seeley Brown.
Chair, I think Mrs. Seeley Brown had her hand up before me. I think so.
Okay, Mrs. Seeley Brown.
My hand comes down, Chair.
Okay.
Chair, I think that Senator Johnson, I think Minister Johnson Smith wants to say something. She typed something in the chat.
Oh, welcome,
Hi,
Minister.
Hi. Hello, Chair. I've been here for a while, you know, but I've been in and out. And
it's most unusually when you enter a room and you are quiet.
As usual, as unusual as it is, it does happen. But thank you. Just on this particular issue, I do think that you know, this is an issue that I think I had picked up on at an earlier stage of the committee as well, because it is a concern to me. Us seeking to make this bill all things to all people, and then ending up in a situation where the type of protection that we need is watered down in some areas and too strong in some, and then you end up with not getting the sort of buy-in and full press for you know, the opportunity for a re-socialization, a rethinking of how we treat with matters of harassment, and how we define it is key to that. So the issue of taking out of the realm of criminality any sort of sexual, whether incentivization, if you want to call it grooming, or expand the grooming, expand the definition of grooming elsewhere. If we seek to put that in here, in this bill, so that it becomes a part of this civil approach, where the issue is about influence in a particular area, in a particular institution, and about a power dynamic which generally should be exercised among adults, but not, but with varying power, with a different power dynamic between them, or power asymmetries, then I think that we will have difficulties down the line. The act of interfering with a child in a sexual way, or making any sexual conduct a condition, whether it is for grades or any other thing, should be a crime, and not a matter for a tribunal, you know, to be discussing whether, you know, whether an environment was hostile or not. Children should not be dealt with in a particular way, otherwise it is a crime. We need to draw a line. Just my view of the matter is in that respect. So yes, educational institutions do need to be treated with, from my perspective, as they have been included, but I have a real concern about us trying to put everything in and then ending up not actually achieving our goals. So if, unfortunately, I was absent from last week's meeting, and it sounds like this issue was very engaged with deeply. Yes. So I'm sorry I wasn't a part of those discussions, but and I'm hopeful that what I'm saying is not totally at odds with that, but it does sound like at least some persons may have had a similar view. So I would be interested to know whether there is there has been any consideration of what would be otherwise placed in, let's say, the Sexual Offences Act or the Child Care and Protection Act, because both are due to come back to us as a parliament with recommendations for amendments. So the time is ripe to say that this is something that should be placed in there, that in addition to what the Joint Select Committee recommended in terms of enhancing those provisions, this committee could recommend that enhancement is also made to those provisions to ensure that we're capturing everything with the appropriate penalties, because the tribunal should not now be asked to determine a matter like this and then send the matter to be treated with criminally, because, you know, what, A, we don't have capacity. B, why do you want to be putting a child through all of that and through different administrative and prosecutorial processes? You know, they say you traumatize the victim and re-traumatize the victim every time you have to put them through that. And so that I think we should try to streamline and ensure that where we're dealing with criminal, we deal with it in the right place, with the right penalties, with everyone focused on saying, yes, this has to have the strongest of penalties. And then here we deal with the balance that you've been seeking to achieve in respect of ensuring that you protect vulnerable persons from a hostile work environment, and ensure that the panel, as it is deemed to be comprised as it is now, be appropriately qualified to address such matters.
Chair,
yes,
may I
Senator
say
Scott
that I am to Senator Kamina Johnson-Smith that is exactly my view. And what was bothering me is this suggestion that a child could, in fact, welcome an advance. I agree with the recommendations you have made. I hinted at them, but did not make them in such detail as you did, nor so eloquently. But I think that is the way we should, anything to do with children, sexual advances to children, must be a criminal offense, and it must be dealt with the stiffest penalties. We cannot condone it. On that note, Chair, may I ask to be excused?
It's so unfair that you make such a great point, and then you want to seek to excuse yourself.
I'll represent you for
Senator
the meeting,
Kamina Johnson
Donna.
knows I'm not in my library today, so she knows that I have a little thing that I have to do in order to get home.
Yes. Be safe. Thank you.
Thank you. Thank you.
You know,
yeah.
Minister, yes. Member Sibley.
I also concur with Senator Johnson-Smith, and it was in line with our discussion last week on the matter, that we felt that children, anything pertaining to children, in the context of the manner in which the fact that children are not able to consent, and it is gruesome. It would not fit in the same definition as we are trying to do here. So, but I think Senator Johnson-Smith had said it much more clearer than I could have ever had.
Thank you, Member Siblings. We know where your heart was last week. Senator Longmore?
Yes, Chair, thank you. I lost connection for a bit there and came in just before Minister Johnson-Smith spoke. And without a doubt, once a child is involved, it escalates to a criminal situation. That was the nature of the conversation. But I also want to underscore also the aspect of putting the victim through the reliving of the experience, and especially for a child, that could be even more damaging. So in my mind, there is no question. I think this was what we discussed and expressed last week. There is absolutely no question as to where we should go with that direction. Thank you.
Thank you. You know, Minister Johnson-Smith, in you representing the matter this afternoon, it was as if you were here with us last week, because some of the points that were raised were in fact repeated based on your submission. And maybe you had a fly on the wall. But it then tells us your own thinking of the matter. one of the things when I raised it was the gray area where a tribunal in this case, based on the award, would seek to make an award of compensation. And would the tribunal, would it be reasonable and fair to compensate in such a situation that involves a minor? And one of the things that came out of the committee last week and what you have represented would have been for us in our report to strongly direct and encourage that the other legislations may be so guided to treat with this matter that would have presented itself during these deliberations. And so I think the committee supports that direction. So Ms. Grant, we now can go to number 37.
Yes, Chair. 37, just to say that one comment made there was made by the Ministry of Tourism, and the gravamen of the comment is that all the offenses have the same weighting, so the same $1 million for each offense, and they are of the view that it seems to bespeak that all the offenses have the same level of seriousness, which in their estimation is not so. And so they think that the monetary penalty should reflect that. Just to say, Chair, just to give some context as they go into discussion, that initially in the previous iteration of the bill, we had so put it like that, where different offenses attracted different weighting. And there was some sort of an outcry that we were not according to the offenses, the seriousness that each offense needs to be treated with. And so that is how all offenses, the monetary value was now put for 1 million for each, and so.
Any comments, colleagues?
I'm not sure, Mr. Chairman, are we saying that we are keeping them as 1 million across the board, or was the position that we would be making some adjustments? I didn't catch that.
The submission was for adjustments to be made with varying degree depending on the gravity of the offense. And so what that would do is that it would cause for the technical team to go back and make the review and apply the different penalties as prescribed in relation to the various offenses.
Okay. Supported, Mr. Chair.
Okay. So that would cause for us to look at all of 37 then, Ms. Grant, and see how it fits in.
Yes, Chair. All right, so 37 then. So let's begin with 37.1, which really speaks to failure to...
Minister Johnson Smith, you want to hold the chair for me for 2 minutes while I go sign a document, please?
Sure, Senator.
Okay, Chair, so that would, just going through all the offenses in 37, then 37.1 relates to failure of a person to attend a hearing when directed to do so. That's the first. That's 37.1. 37.2 deals with without reasonable excuse, you fail or refuse to furnish information or produce documents under the Act, you also commit an offense. 3 speaks to the witnesses, where any person appearing before the tribunal as a witness at a hearing refuses or fails to be sworn or make an affirmation, or you refuse or fail to answer any question required to be answered by the tribunal. 4 takes us into any person who interrupts proceedings, uses insulting language, publishes anything in contravention of clause 33, and just for context, 33 deals with a prohibition on publishing evidence before the tribunal. Any person who permits, divulges, or communicates any particulars in contravention of Section 26, you furnish to the tribunal misleading or false information, and those are the offenses covered in 37.
Okay, thank you, Ms. Grant. So, and all of those offenses are offenses which now attract a fine of up to, a penalty of up to $1 million?
That's correct, Chair.
All right. So are there, maybe we could ask the technical team, are there precedents from other legislation that would allow us to adjust, while it is clearly that they would have a tribunal to go up to? So clearly they have flexibility. I do support, if as chair, I'm permitted the privilege, although I can step out of the chair and just continue this as a intervention, because I see Senator Gale is back.
Yes. Yeah, let's hear
Right.
your intervention, Minister.
Just to say that, you know, there are some that, you know, are that appear a little more on the, you know, the difference between divulging confidential information about a case and or failing to give evidence, as opposed to some of the more minor ones. Are there precedents, whether in the, were some of these considered with the Commission of Inquiry legislation when that was reviewed? Are there some adjustments that could be made to sort of delimit what might be more serious versus less serious in this Section 37, or do we have a sense that all of them have the same general seriousness, but should be less than $1 million and perhaps be closer to 500,000 up to, just to get a sense whether the technical team had looked at that?
Or would, given the concerns raised, would they be minded now to look at it?
Yes, absolutely. Absolutely. I do remember the refusal to give evidence or to be sworn. I remember that coming up with the not one word, if you recall. And I think that was addressed in an amendment to the legislation in respect of commissions of inquiry. I don't recall if it was a fine of up to $1 million. I think it may have been less. So I do think that there may well be precedents in other legislation that would allow us to delineate a little more, or to be a little more, to sharpen our pencils a little bit in respect of where the fines are put, the upper limit of each fine is. Maybe just two more, a 250,000, a 500,000, and then $1 million. You know, having 3 layers might be a little more.
Having some variations depicted in layers. Because when you look at the transgressions, interrupts the proceedings at a hearing. I mean, a lawyer could just very well interrupt it in making a defense and not having their own way, as opposed to, you know, another one that says you furnish the tribunal with information that would have been either misinformation, which in my mind is a different degree of misleading the tribunal.
Absolutely, that's fundamental to the credibility of the process and the credibility of evidence. That's very different from disruption. Right. Disruption may well be a $50,000, but I don't want to make suggestions like that, because clearly there are technical minds that are more experienced on these matters. But the distinctions you just draw, Mr. Chairman, are appropriate, I think.
So we would therefore ask the technical team to go back, examine it, and make recommendations. So, Ms. Grant?
Yes, Chair, I am making a note.
Yeah.
All right, so that
I think we're doing very well, you know. We can go on to 38 now. This committee is working very efficiently.
that would take us, yes, Chair, on to 38. And the consideration that we just looked at in terms of the varying degrees and the weight, that's also a concern that's levied against 38. And another being in relation to 38.1, where it speaks to any adverse action. The comment was made by Ministry of Labor and Social Security. What constitutes an adverse action? So it says a person commits an offense if that person hereinafter referred to as the first mentioned person subjects or threatened to subject another person hereinafter referred to as the other person to any adverse action. So they are asking what?
I recall us agreeing in the initial stages of these proceedings for the section 2. Section 2 for us to deal with those definition areas at that time, at the end. And this is one of them that came to my mind, that if we are not clear as to what adverse action would be, then we can so define it, make it clear for all, and apply it in the definition in section 2.
Oh, but Mr. Chair, and I stand to be guided, but my understanding of definitions of terms in legislation, if it's not used more than one time, and if it is not given a particular definition, then you would accord to it the ordinary dictionary meaning. That's
Okay,
my understanding.
All right, I'm guided. I take guidance very easily. But how do we treat with that particular concern that would have been raised by the Ministry of Labor then?
Well, that would depend on which dictionary definition we're using.
You see, they would have raised a concern, but they raised the concern by just applying a question and not a recommendation. Ms. Celie Brown, Solgen, any comments?
And recognize that adverse can be quite subjective.
Ms. Grant, that would have been their only concern, right? Correct?
Yes, Chair, that was the only concern by the Ministry of Labor.
I think that is something that, I mean, what is the technical view on this, Mr. Chairman? The language, as has been stated, is I mean, it's not technical, it's not a term of art, it's not scientific. It is the ordinary interpretation, or the normal dictionary meaning would mean something that has a negative impact. And the grounds are there. That is the basis of the adverse action, rather the context that's there. I'm not sure how one would want to limit this language. Was anything further said about?
No, nothing further was said. It's just that they asked us to define it. And when I'm looking
if you define
through
adverse, you end up in a problem of what you leave out or what not. The word adverse is broad enough to allow in the context for a tribunal to interpret it in the context in which the case is made. I would hesitate to try to define this, Mr. Chairman.
When I look at the clause itself, I'm not seeing where it would impact it, whether negatively or positively in any way, by making that determination. So I would.
I would hasten to think that this also is used in other legislation, and it is usually interpreted in the context in which it applies.
Right.
I don't think this is new to this legislation.
That being said, I think we can move on, except for Ms. Grant, look at 33A3. It says, has attended or proposed to attend a hearing under this act or to appear. What is that word after appear? Should we take out the AT and appear there as a witness?
Where are we, Mr. Chair? I'm sorry.
38(1)(a)(3).
Okay.
Has attended or proposes to attend a hearing under the act or to appear
thereat.
Yes,
sir.
As a witness. Oh,
it's
so thereat. Okay, I see. All right, so we can move on to 39.
I would say so, Mr. Chair.
Ms. Grant?
Yes, sir. So I also made a notation about the penalty regime, which was something that was raised by the Ministry of Tourism yet again. So 39, that was really the only suggestion. The same thread coming from 37 through to 38 made by the Ministry of Tourism, the variation of the offense regime. Specifically because 39 deals with making false complaints, and it has the same 1 million weight. So this was one of them that they said should be given a higher penalty.
All right, so we can review that in the same way we're reviewing 37.
37 and 38, Chair.
And 38. So we can now move on to part 8, number 40.
Yes, Chair. 40, just a plug here that was made by the UEU Share Labor Institute that the regulations don't take long to come. That was really the only suggestion.
Okay, we can agree. But it determines what it means by taking long. But that would have been a natural concern raised with many legislations.
So 40 remains as is. Going on.
Right.
Clauses 41 to 44, no suggestions were made from either of the three matrices.
Any comments for colleagues? 41 to 44?
No, Mr. Chairman, doesn't seem so.
No comments. And the schedule?
Mr. Chair.
Yes, ma'am.
I am just looking at 41.
Yes.
That speaks to the tribunal being able to regulate its own procedures. And here, to my mind, this clause would take in the tribunal's authority to make its own rules. And I don't see anything there about the fact that the rules must be gazetted.
Okay. Yes, Member Campbell Rodriguez. Senator.
Yes, thank you.
Yeah.
I can't raise my hand. I don't have that functionality. I'm not sure why. In 42, where it says the act shall be reviewed from time to time, that's rather subjective. And for example, the Cyber Crimes Act, it states it should be reviewed every 3 years. I am suggesting that we also make it very specific, like a 5-year review, etc. But from time to time is just a little bit too subjective in my mind, unless there's a specific reason we're calling it we're saying time to time.
I'm so sorry, Mr. Chair. I don't mean to interject, but through you, Member Rodriguez, if you want to look at subclause 2 of the same 42 and see if you still have that concern.
I'm just a bit more specific, but that's a personal thing, which is why I'm raising it so that, you know, others can look at it and see how they are. But
so my
also,
understanding, sorry, go ahead. Go ahead.
No, I'm just saying, I'm wondering what's the reasoning behind not being specific?
All right.
Because maybe that will satisfy me somehow, just to understand the reasoning.
We have Ms. Aldred and we have Minister Johnson Smith. Minister Smith, Johnson Smith, you want to go first?
No, thank you, Mr. Chairman. I'll allow, of course, the technical response first. And
I was saying you go ahead, Minister.
Just to say, hello, Senator. It's a pleasure to see you. To see you well.
Pleasure to see you.
The cyber crimes, I know, because when that bill was first drafted, the sense was that that particular area is so dynamic that the nature of that legislation would require consistent review, because you would have circumstances where technology continues to outpace the legislative process, whereby this, which is sort of fundamentally an administrative process that you hope will be able to manage different circumstances, and it's the circumstances that would change, but not the law. We pass it, and in 5 years, review it in the context of how it has operated, and then you would adjust, you would review again as necessary. That's the thinking, rather than to mandate the Parliament to review, even if review is not required. As you see in circumstances like now, when we have 7 joint select committees established, and there just really isn't the time even. So I think that was the balance that was sought here. You said the first, as opposed to cyber crimes, which of its nature requires consistent updating. And even then, I think we've missed a slip or two.
Yes.
Okay, I understand that reasoning, and as such, I am fine. Thank you.
SG, you agree with me?
Oh, of course, of course. Yeah. Well said. I can't add to it at all. Yes. Because I was saying the same thing, which is that there is a 5-year review, and I'm always in favor sometimes of giving a little more time for review. In fact, I have had my position is not always one favored by committees, but sometimes when we put a 2 or a 3-year review, the law has not really yet been tested. And so what happens is persons come, but you don't really have proper submissions being made because the law has not been tested. So I support a 5-year first review, and it says no later than, so nothing prevents an earlier review. Give the law a little time, let's see how it works, and then you have the review. And then after that, this then says it must be under continual review. It just doesn't give the time frame. There are some laws that actually don't even say that. It just has a first review sometimes and gives a 3-year. So at least this says you still must have it under continual review, but just doesn't give the time frame for that. I actually had my hand up also for another reason. So I did look at the Commissions of Inquiry Act as it relates to the penalties. In clause 37.4. So I don't know if I could proceed, Chair, because it's a different provision. Okay. Yes. So as it relates to, I'm looking at clause 37.4, and as it relates to A and B, which seem to be contempt provisions, interrupting the proceedings, using insulting language, seems to be contempt to me. And the contempt offense in the Commissions of Inquiry Act at Section 11L attracts an offense of $500,000, default of payment 1 month, custodial. As it relates to publishing anything in contravention of Section
default 30, of payment is only
right. It's not fine or punishment. It's if you don't pay the fine, default is 1 month.
Okay.
Yes.
Okay.
Sentence not exceeding 1 month. As it relates to publishing anything in contravention of Section 33, I found a similar provision in the what I loosely refer to as the Anti-Gang Act, the Criminal Justice Suppression of Criminal Organizations Act, Section 17. And the provision there is it's a dual regime or dual jurisdiction. Before the parish court, it's 12 months, it's 1 million or 12 months, or both fine and imprisonment. In the circuit court, it's to a fine or to a term not exceeding 5 years. But again, you would understand that that law, the anti-gang law, you can understand why you would have that higher jurisdiction, meaning the circuit court jurisdiction. But it was 1 million before the parish court, 1 million or 12 months, or both fine and imprisonment. For E, furnishing to the tribunal false, misleading particulars, 11K of the Commissions of Inquiry Act has a similar provision, and the penalty was $500,000 or 3 months. So this is a fine or imprisonment for 4E when you look at it from the Commissions of Inquiry, Section 11K. So you will note, though, that 4, what we're looking at in the bill, it's a fine, and in default of payment, a custodial sentence. So there are some variations from what you have in some other laws. I would need more time to look for offense of making false complaints. To be honest, I'm not sure. I'd have to think about that a little bit to find an offense like that. There are other offenses, but not of making a false complaint. You may want to think, though, that this would be a serious offense, especially
for this
yes.
particular legislation.
Yes.
And especially where other members would have raised the concern against the alleged in the protection of the alleged perpetrators.
Yes. So, for instance, I would invite the committee to consider whether this should have a default provision or if it should be a fine or imprisonment or both to act as a proper deterrent. So you can't just pay your way out, so to speak. Because technically with this offense, you could pay your way out.
Mm-hmm.
So I'm just saying that is something that you could consider.
And so our consideration would be based on the guidance that may be provided by the technical team. If you would be able to find a comparative legislation that supports this particular clause. Is that a reasonable request?
It's very reasonable, especially since Legal Reform Department is also on the call.
Yes. All right. So we will await then the technical team getting back to us with respect to these particular areas. Just to say, in dealing with 42, I accept the submissions made and in pointing us. One of the things that jumped out at me really was where, for the first time, I believe I'm seeing the act to be reviewed from time to time and not stipulating a defined time period for that review. What it does in my mind is, even if after the first review, it gives us the opportunity to make other reviews. Again, for me, this being a new legislation, a time frame of 5 years is very, very good, because it gives us the opportunity to assess the various moving parts. The question of putting in the regulations, see how the regulations work, also the code of practice or guidelines to which we had suggested, and to see how that works, and to see how the tribunal would operate over a defined period, bearing in mind that there's another aspect of the legislation that we would have had deliberate and detailed discussions on last week in terms of that time frame in which someone can present a case, moving from the 12 months to what we had agreed on. Again, we have to see how those things work. So 5 years in my mind is very reasonable in terms of a review.
Chairman, the only concern I have there is what it relates to the cyber crimes is virtual sexual harassment and sexual harassment that is technologically related. And therein lies that little need. While sexual harassment itself is somewhat very, the situations can be quite defined and not evolving and changing. When it comes to the virtual aspect of sexual harassment, that we have to keep abreast with. And I think the Cyber Crimes Act provides for such. So I think we should be covered in all respects, hopefully.
Well, the good thing about this legislation is that it's taking into consideration all means to which sexual harassment would have taken place.
Right. So that's why I'm saying that in considering that, we have to keep this piece of legislation up to date with what could happen virtually.
Well, let's see how the other one goes.
Yeah.
Miss Grant. So there were some areas that we would have placed in a parking lot.
Yes, sir.
You want to remind us of those?
Well, Chair, where we are now, we have to go back to clause 2, which is the interpretation section.
Yes.
Excuse me, Mr. Chair.
Yes.
I'm not sure if we had completed section 41 where Ms. Grant was suggesting about the tribunal being gazetted.
Oh, thanks.
About the rules, Chair.
Right. Committee? Subject to the provisions of this Act, the tribunal may regulate its proceedings and proceedings as it thinks fit, and may prescribe forms to be used in connection with complaints brought under this Act. So the only addition to that is for such rules to be gazetted. Are we in agreement with that, members?
I am in agreement.
Chair, would the forms also need to be gazetted?
Sorry?
The forms,
Yes.
but the forms also need to be gazetted.
I would say yes, Mrs. Celia Brown. And in fact, what I was going to say is that the provision would need to be tweaked a bit to provide for the rules, because it doesn't actually use those words. So it would need to say that the tribunal can make rules.
Agreed.
Which would include the forms. The rules would include the forms, and then you would gazette the rules with the forms.
So what would the total amendment be then?
It will be Chair to have the tribunal make the rules, and then the forms will be part of those rules, and they will be gazetted.
And they would be gazetted.
Rules will be yes.
All right. So we can now go back to clause 2, Ms. Grant?
Yes, Chair. Okay. So these
sorry,
are...
Chairman, did you put the schedule to the committee?
Oh, sorry.
Oh, yes.
It's a big thing.
Yes.
It's an oath. It's an oath.
Yes, thank you. So I'm now putting the schedule. We can agree.
I imagine this oath is pretty standard. That's kind of, I'm not au fait with the technicalities of it, but this seems pretty standard.
So members, we
I
can
have
go with
nothing
this.
to add. I am fine with it as written, but I stand to be guided by the technical team.
Yes, it's standard.
Okay. And then on page 24. The memorandum of objects and reasons. And it targets the 3 areas: employment related occurring under institutions and arising in the landlord and tenant relationships.
You know, a lot of persons are going to be wondering about street harassment. The construction sites.
I think we had taken the decision that even though those matters were part of the deliberations, it would have formed part of our report in indicating that there were matters of grievous concerns that other legislation would seek to address, if I can recall. So it's for us to have, having heard the submissions and the calls, we're so minded to highlight it in our report for those matters to be addressed elsewhere in other legislations where I believe they belong.
That's my recollection as well, Mr. Chairman.
Okay. So we can now go back to clause 2.
Mr. Chair, I just wanted to indicate on the schedule bit that we would have some more things coming in a schedule. I can't locate the notes right now, but just off the top of my head, I know that we had agreed that, for example, the complaint form, we would also put in a schedule to help the, right, and some other things.
And would that also include the code, or would that wait later on? In other words, we spoke about a code, some sort of a guidance in terms of what a policy would look like.
Oh, yes, the policy template, yes.
You're right, the policy template.
Yes, Chair. We had said that that would go in a schedule as well, yes.
Okay. Mrs. Seeley Brown?
It was in reference to that same point that it should be in a schedule. The agreement was that it be incorporated in a schedule to the bill.
Right. So list the things now that we said.
The complaint form and the policy.
The complaint form.
The policy.
The policy.
The schedule in relation to the policy.
Right. Okay. That's it. So we can go to the interpretation clause now.
Yes, Chair. So these are the comments made in relation to the interpretation clause, and I'm going to go through the comments matrix by matrix. So the comments falling on the matrix 1, the Independent Jamaican Council for Human Rights indicated that there is no definition of landlord or tenant, and that the terms lessor and lessee, which are relevant, are not included. The Norman Manley Law School suggested that we define the term workplace, and they suggested that we could look to the Canadian Labour Code for guidance that defines a workplace as any place where an employee is engaged in work for the employee's employer. Jamaica Lands recommended that we expand the definition of the word institution by adding private sector businesses. I'm going to read this just the same, but I don't remember what was agreed. Add a section that addresses the possibility of workers of companies or businesses sexually harassing clients. Jamaica Aid Support for Life proposed that the word written be included in the definition of sexual advance to capture any perpetrator who may choose to harass an individual through letters or any other form of written communication. Ministry of Tourism indicated that we rethink the use of the word unreasonably, specifically that it be deleted from the sexual harassment definition, which reads interfering unreasonably with the work performance of the person to whom the sexual advance is made. As they say, it could give rise to a defense that interference was reasonable.
Where was that reference in terms of that particular clause?
This sexual harassment definition in clause 2.
Clause 2.
Page 3.
Yeah.
All right, Women's Empowerment for Change, We Change. They suggested that we look at regular sexual harassment training with staff and human resource management personnel, that we include the definition of harasser in section 2, clearly defining an harasser as, well, to include third parties. And they suggested something similar to what the U.S. Equal Employment Opportunity Commission has, to say that the harasser can be the victim supervisor, a supervisor in another area, a co-worker, or someone who is not an employee of the employer, such as a client or a customer. They also propose that we include online sexual harassment in the act that complements the Cyber Crimes Act, but doesn't separate itself from the Cyber Crimes Act. And those were the comments in Matrix 1. In Matrix...
Sorry, Mr. Chairman.
Yes.
Sorry, before we move on. Sorry. And
yes.
I think Mrs. Seeley Brown's hand is up as well. I just wondered, the issue of the interfering unreasonably, had that been, is it that the committee had taken a decision not to accept that, or had it been considered by the technical team? I mean, I find that the word interference has its own sort of pejorative, well, let me not call it pejorative, but it has its own imputed meaning, interference. So I'm just interested to know how the Ministry of Tourism's suggestion was considered, because I think it's worthy of consideration.
You recall, Ms. Grant, the specific submission that was made and how we treated it?
Well, the submission was just shared with us. The question is how it was dealt with, or was it dealt with?
That's what I'm trying to get, whether or not we had gone down, and the minutes of these meetings could tell.
Sorry, Chair, but for most of the submissions that were made, based on the length of them, some of them didn't, most of them didn't carry any decisions at the time.
Okay.
So the proposals were made, we noted them, and we moved on. So I'm not sure that there were any decisions particularly for any of the definitions proposed.
Mrs. Seeley Brown?
Chair, can we go through them? I think we're going through, we're just reading the comment and we're not making, we're not having discussions or making decisions as to what we are adopting and what we are not accepting. I want to go back to Ms. Grant said something about private sector businesses that I didn't fully get the comment in respect to an inclusion of private sector business in a particular definition. Can you go back?
Can I suggest a different approach then? Can we take them one by one?
Yes, yes, please.
And then in taking them one by one, if the arguments in relation to the submissions could be put to us, that in such a way that could remind us as to, you know, what the thinking would have been by that stakeholder group.
Yes, Chair.
So the first one I recall was...
I can go again, Chair.
Yeah, and let's take them one by one.
No problem, Chair. Okay, so Independent Jamaican Council for Human Rights, this was their submission, that there's no definition of landlord or tenant, and that the terms lessor and lessee, which are relevant, are not included.
Okay, so let's take that one.
Chair, I can't recall seeing those definitions, so seeing those terms defined in other legislation, because they take on their ordinary legal meaning. I'm not sure if we're not going outside of the ordinary legal meaning of these terms, why are we defining them in this particular piece of legislation?
Any other comment?
Mr. Chairman, I don't have a difficulty with that perspective. I don't know, I was trying to find where the term landlord and tenant, I was trying to find it back where it's used.
It's not used, Minister.
Oh, but the landlord tenant relation.
But it would be 9, clause 9.
Yes, clause 9.
Right, okay, so just looking to see what actual language was. It's about providing or offering accommodation.
Accommodation.
So there is no use of the terms.
No.
Which means that it's actually broader. So you could be a licensor or a licensee, or you could have no contractual relationship. You could just be having someone stay with you, and without any sort of legal framework. So it is as broad here as one would want it to be if one were a vulnerable person. I think a definition of landlord and tenant, or inclusion of lessor and lessee, you know, they should be the same. You will limit it, because then you also need to get in a licensor and a licensee, and whether they're bare or otherwise, if you start to try to break it down. So I wouldn't recommend that we start to define. I don't know if there's another type of approach, but that doesn't seem to me. This seems to be the broader one, capturing everyone who might be vulnerable to someone that they're sharing accommodation with.
You might just have someone staying with you, or staying with a person for even a weekend. You're providing accommodation. And
what if you're a roommate? What if you're a roommate?
Huh?
It could be a roommate. Meaning, you know, it's not.
You share premises.
I don't think once you're sharing accommodation.
Once you're sharing accommodation.
Or being provided accommodation. I think this is so broad that it's much better than trying to say that it should only be in landlord and tenant, which actually makes me think that we should consider the memorandum of objects and reasons, which is where landlord and tenant is used. It may well be that there we want broader language to say, or arising in circumstances where accommodation, permission is granted for accommodation. Something, I mean, I would leave that drafting, but that's the only place that I think that it should be treated with, not by definition, but by expansion.
Right. Agreed. You have that, Ms. Grant?
Yes, Chair, I'm just finishing up the point right now. Okay. Second point, Norman Manley Law School proposed that we define the term workplace, and they suggested that we look at the Canadian Labour Code definition that defines workplace as any place where an employee is engaged in work for the employee's employer.
So in my mind, I had raised the concern about the definition of workplace for it to be so defined in this legislation for varying reasons. Mrs. Seeley Brown, you. Yes, Mrs. Seeley Brown.
Chair, same point that Senator Johnson Smith just made. I can't remember us using workplace in this legislation. We spoke about
Work environment.
A work environment.
So it was at a later meeting where Senator Johnson Smith and Minister Chuck had taken the discussions to a level that invited our attention around work environment in such a way where you could still be out with a co-worker and be harassed. And the thinking would be that you're still in a work environment. And so rather than limit the term workplace, work environment, which meant you're still engaged with a colleague at work and still exposed to the risk of harassment.
So then we can't use it to workplace, Chair.
No, and that's where the discussion had taken us.
So perhaps it should be work relationship. That would cover place and in a physical place, as well as in a space, as well as
in a workspace.
Yeah, so it workspace or work relationship.
Because, you know, again, I remember that particular case in a South African jurisdiction, which gave rise to the individuals traveling somewhere. And there was the feeling of one employee being harassed by the other. And it became a case, a matter of case law. Ms. Grant, Mr. Seeley Brown, your hand is up. Ms. Grant, you want to go ahead?
Yes, Chair. I was saying to the point you made about Minister Johnson Smith and Minister Chuck, the point that was made in that meeting was that we would not confine workplace to walls, but we would look on it in terms of relationship. So it was once a relationship exists between the parties and sexual harassment occurs, that it would still be treated with. That is what was said in meetings gone by as it relates to that. So I don't know if we would still be going with that. At the time, it seemed to have been met with some amount of consensus. So I'm not sure if we're still going with that or we're going to treat with a workplace or what definition under the bill.
Isn't 7.1 wide enough, Chair? An employer or a supervisor shall not sexually harass the worker. It doesn't confine it to the workplace.
So here is the challenge with that, Mrs. Seeley Brown. An employer or a supervisor shall not sexually harass the worker. But I remember that specific discussion surrounded also colleague to colleague, as well as the employee harassing the employer.
That's captured by 7.3 though, because a worker shall not sexually harass a co-worker.
A co-worker, okay, so that deals with that.
I think that there is a question on which I would like guidance. That your most latter point, Mr. Chairman, about the employee harassing the employer. I do recall that some colleagues had raised that as an issue, and I'm not sure whether the technical team would capture that under worker and co-worker, because the use of the prefix co seems to denote to me some level of equality. Yeah, some level of equality in terms of level, work level. So I'm not sure where the committee landed on that issue. I know I've missed 1 or 2 meetings, so I'm not sure if that issue was taken further, because that I don't necessarily see captured here. It's quite employer, supervisor shouldn't harass a worker, employer, supervisor shouldn't make it appear to a worker shouldn't offer any disadvantage. Sorry, a worker shall not harass a worker, and a prospective employer shall not harass a person seeking. So I'm not sure that I see that what they term sometimes as reverse harassment, but I wouldn't call it that, because it just depends on how you define harassment. But in terms of the power dynamic, is that captured elsewhere?
Chair, through you, if I recall the conversation, the discussion that the minister is referring to, and I think that was where we evolved to work relationship, because that would cover all the possible power dynamics and interplay that would occur. So I think, I don't remember where, but that was where the proposal was for using work relationship. So I can't remember if it was 723 B3, 2B3 with worker, sexual harassment, co-worker, or co-worker in a working relationship, something to that effect. I think that was what was suggested.
Chair.
Yes.
Legal reform has just brought to my attention the Sexual Offences and Domestic Violence Act of the Bahamas. Section 26C speaks of the scenario that Senator Johnson Smith, the scenario that she raised it down up, and it, and yeah, as an offense of sexual harassment. So Ms. Grant, if you could look at that provision, Section 26(1)C of the Sexual Offences and Domestic Violence Act of the Bahamas. It creates a criminal offense of sexual harassment, but I think it's something that we can look at. And
so we could somehow adopt.
Yes. It says importunes or solicits from a person in a position of authority in any place of employment or in any institution any favor, benefit, or advantage, or the forbearance from the exercise of any right, power, or duty relating to that authority under any holding out or promise of sexual favors is guilty of sexual harassment.
I didn't catch that in terms of down up. It said it's just
from
a whole.
Yes, because it's a person, and let me read the entire thing. A person who importunes or solicits from a person in a position of authority. So that's your boss. So that's like your boss in any place of employment or any institution, any favor, benefit, or advantage, or the forbearance from the exercise of any right, power, or duty relating to that authority under any holding out of or promise of sexual favors is guilty of sexual harassment.
But it still doesn't, I never picked up the down up situation in that. In other words,
if I say I'm not going to do my job unless my boss puts out for me, is that what that means?
Yes.
I am not going to do my job unless the person to whom I report does me a sexual favor.
Yes.
The person to whom I'm accountable for doing my job and who can fire me.
Yes. That is what it is saying.
Okay, I think that, and I think this was my position before as well, that I think culturally we would have a hard sell on this with the public. But I do recall that there are persons on the committee who feel strongly about it.
Yes.
But I'm noting for the record that I think that it is going to be an aspect that will be strongly criticized, unless an approach can be found in the language that somehow maybe my mind is too closed. But I think
they don't quite like it. It could be tweaked.
I don't know. I just think that if that were to happen, it would trigger a different action from the employer.
Indeed.
Yeah?
Indeed.
And then another jurisdiction and another tribunal may very well have to deal with that.
The worker would.
And would it not be a defense, Mr. Chairman? Would it not be a defense to say that I fired the person because they A, did not do their job, and B, they had the effrontery to say that they would not do their job unless I performed a favor?
Yeah.
Come on.
Yeah. And it's a criminal, and it's also a criminal offense.
Well, maybe we're trying to.
Chair.
Yes. I see member siblings. So let me recognize member siblings first.
Can I ask that Mrs. Silly Brown read that once again? Because when upon the first and the second reading, it came across as if it's up, down, and down, up.
It's not.
So
I'm gonna read
it never captured down up.
It does. Down up.
So I want her
down up is in another section. It's I'm just reading a paragraph of that entire section. So it starts. You understand?
So can you read the down up for us then?
The down up. That is the part where I would like to wrap my mind around.
Right.
Please.
Yeah. Right. So it says a person who being in a position of authority over or being a co-worker of another person in any place of employment at any institution importunes or solicits sexual favors from that other person under any holding out, promise or threat of the grant or imposition of any favor, benefit, advantage or disadvantage, as the case may be, at the place of employment or institution is guilty of an offense of sexual harassment. So that's it. That's up, down, up, down. And then down, up now, the C is importunes or solicits from a person in a position of authority in any place of employment or any institution, any favor, benefit or advantage, or the forbearance from the exercise of any right, power or duty relating to that authority under any holding out or promise of sexual favors is guilty of the offense of sexual harassment. So there's
try it if you're bad.
I mean, I agree with Senator Johnson Smith. It will be a hard sell in our, in our society, but it is in the Bahamian legislation.
The issue with this,
criminal offense.
Yeah. The issue with this for me is that you would want to seek possibly to capture all scenarios where possible, where the complaint can be triggered. And in this case, we're looking at, in the working relationship, whether parallel, colleague to colleague, or down up, up down, or institutions, or landlord situation, the accommodation situation. Yeah? We're trying to capture all scenarios.
Chair, I must say to you, and I'm being reminded, it's only in the Bahamian legislation we have seen this. I've not seen it in any of the other sexual harassment legislation. So there could have been some policy decision that was taken or some mischief that they would have been trying to to solve when they, you know, when they, I would personally, I would like to see the Hansard as to why this provision may have been included in the legislation. It may be interesting because it's not in any of the other legislation that we've checked.
And whether or not it came in the primary legislation, or whether it was been an amendment.
And let me see. I can check that. No, it was, and it's the Sexual Offences and Domestic Violence Act. So as I said to you, it's a criminal offense.
It's a criminal offense.
There may have been some mischief here that day, yeah.
Senator Longmore.
Thank you, Chair. This was something that I had raised in the committee, and the scenario that comes to my mind when this might be applicable is the female supervisor on a construction site in a community where the construction workers are from that community. She may be from that community, or the person, the supervisor may be from that community, and they harass her. You know, the calls, the et cetera, et cetera, et cetera. And that is defined within the work relationship or the work environment. Now, I am very conscious of the fact that when it comes to women and women employment in Jamaica and the progress of women in terms of taking on managerial and supervisory roles, I think it would be remiss of us to not include this provision. I don't think it creates it takes away from the act in any way. I don't think it creates any avenues for misuse. And I think that as women within the society progress and aspire and move towards these supervisory roles, that we need to provide for these circumstances. And so I firmly believe that we should provide for the bottom-up harassment because it does occur. Thank you.
Thanks. So this discussion started out in trying to define where it actually happens or where it's possible for it to happen. Whether the location, whether or not you could be on a company transport, whether you could have gone to training, whether you could have gone to an event. But then the discussion led to where both of you could have been just casually having a drink and the harassment would have occurred. Or again, in this time when we are working remotely, the question of work is only a change of the geographical location where you are working from home, but you stand the risk of being exposed to harassment by the same virtual medium. And so I believe that's why we came up with the thinking of, let's treat it with work relationship. And let's treat it like once you are within the same organization to which you are employed, no matter who or where you are, the working relationship exists. And that ought to be the trigger in treating with it.
Chair.
Yes.
But don't you think that that is covered under subclause 3 or clause 7? In simple
and because you have directed us to it, it gives us the opportunity to take a second look.
Yeah, I think it's a worker shall not sexually harass a co-worker. So all of the scenarios that you would have raised there, Chair, would be covered under subclause 3, I think.
No, the situation there was the drawing of a parallel between co-worker and co-worker.
Was that what you? No, that's not what I understood.
Yeah, man. But so this would deal with the only thing that would not have been dealt with in this scenario is the up-down situation.
Agreed, Chair.
That's the only thing that would not have been dealt with.
So that's a policy decision, Chair, that the committee is going to have to take in relation to whether you would include the bottom-up situation in this provision. Similar
could we possibly widen? I'm not hearing.
You mute. Still not hearing you, Senator Longmore. Not hearing you. So,
may I go ahead?
Yes.
Senator, more
yes.
Technical issue is being resolved.
Yes, member siblings.
Working environment. The word environment, is it not expansive to deal with if you are at a function? Isn't that a working environment? I am not sure we need to go more than saying a working environment. You never say workplace, but a working environment, which can be quite expansive. I don't know. I would wait on the technical people to respond. Thank you.
In addition, Chair, if you look at page 4, you would also note how widely the worker is defined in the legislation. So employer is defined. It is also very wide, a person who engages in any form, a worker. And then worker is defined on page 4. So I think the issue would be do we add to anything here if we think that this is not expansive enough? But I don't think we
And
need.
what would we seek to add to capture?
Chair.
You're having challenges, Senator Longmore.
Yes, I don't know. The connection seems to be going in and out. Sorry. What I was wondering is if we could expand 7.3 to include the word relationship. So a worker shall not harass another co-worker irrespective of their work relationship. So incorporate the work relationship in that subclause. I think you're frozen again.
Senator Longmore, is it that you're trying to provide for the bottom-up situation?
Yes.
But I think, well,
I don't know if I lost the solution in my connection. My connection has been going in and out.
I think that would complicate it because then we'll have to look at defining what is a work relationship. If we're going to do it, it's going to have to be if the decision is to incorporate it in clause 7, I think it should be a standalone subclause.
Okay.
That could be a possibility, Mrs. Seeley Brown.
Mm-hmm. Yeah. But the decision
have it as a standalone.
Yes, once the decision is taken by the committee to include it in the legislation, and then we adopt similar language to what we have
seen in the Bahamas.
Yes, sir.
So could the team come back with that and let us see how it looks?
No, but I think so. Is it the decision, Chair, that you are going to want to incorporate it in this legislation? Is that the decision of the committee that you would want to incorporate it?
So we're dealing with treating with that
The bottom-up situation?
The bottom-up situation.
Yes.
Right. And if we agree that we treat it by having a standalone, it is just what that standalone clause would say.
Yes, Chair.
And would the committee be minded to just, once that standalone is represented to us, we examine it and to see how it fits in?
Yeah, Mr. Chairman, I'm still hesitant on this matter, but certainly to review a clause at this stage to see whether it is that it works. I'm not sure whether I agree in principle that that it should be included in the act, but certainly I support, given the strength of views on the committee, that a proposed clause be put forward to include it. I would not propose, for example, a restructuring of our whole of the scheme of the act in order to accommodate it, but certainly to include, if there's a means to include it without changing the scheme as it currently exists, then it would not, it certainly wouldn't hurt for the committee to consider it. But from a policy perspective, I'm not sure I'm agreed, and I'm not sure what the position of the chair is either, who holds the portfolio in the executive.
So I would not be prescribing where there's the inclusion of a particular clause that would create a domino effect in changing the fabric of the legislation and the scope of the legislation. It's a question of just examining what a possible proposal would look like and to see and determine whether or not that proposal can fit into the legislation and treat with also the concerns that would have been raised. Mind you, I agree with the point that if that scenario was to have taken place, then another type of action would have been triggered. I'm mindful of that.
I'm sorry, Chair. I put my hand up on.
Oh, I'm sorry.
That's okay. On the same issue as Minister Johnson Smith said, because to my mind, what immediately started happening is if we put that as a standalone provision in the legislation, then there are certain other clauses that will be affected, which we will now have to cater for this unique relationship in terms of the complaint mechanism. If you so choose to use it, how do you complain? Where do you go? Do you go straight to the tribunal and then to cross-reference certain sections and so on? So there would be other things that we would have to change. But is it that, well, so you're saying, Chair, that we are noting it as something that can be done and we return at our next meeting to see what it looks like and to hear what the Chair has to say?
Minister Johnson Smith, you have your hand up?
Yes, Chair, to come in after Mr. Sibley's.
Okay. Normally it's ladies before gentlemen, but in this case.
Equal opportunity.
Member Sibley's, this had better be a good representation.
Mrs. Johnson Smith, Senator Johnson Smith, you can always represent me, you know? But you know, what I had put my hand up about was with regards to the matter that I had mentioned before, which is the whether or not we need to expand or do anything further to the work environment. Isn't it it wouldn't have captured all the questions that were raised in terms of where's the workplace? Because workplace would put a boundary, so to speak, as we are used to. But the using of the word environment, I am of the view of expanded to just a building, but anywhere where work carries on. That's my
Thank you, MP Sibley's. Mrs. Minister Johnson.
Thank you, Mr. Chairman. I was just going to say that if we're going to consider as a committee and when Minister Grange is back, etc., if we're going to consider this fully, and I really am going to try and do a little bit of independent research on it, just try and open my mind on it a little bit because it is admittedly closed. But I would think that to keep with the scheme, what we would really include in 7 is the converse of 7.1. So you would really say that that a worker shall not sexually harass an employer or a supervisor. You would already have at 3 captured shall not sexually harass a co-worker. So the only other remaining aspect would be that a worker shall not harass an employer or supervisor. And then you would think in the context, it would more likely arise under paragraph A of sexual harassment, which is really that a person should not make an advance that's reasonably regarded as offensive or humiliating. You get, as a principle, no one in the workplace should make an unwelcome sexual advance, which is reasonably regarded as offensive or humiliating. That's as a general principle makes sense. So if it is happening down up, one can understand that. I think the difficulties which come down the line in terms of why is this a matter which then is one now suitable for this tribunal? Because if, as you pointed out earlier, the employer or the supervisor did not take the action which they are empowered to, or if it's a circumstance maybe, and I really am trying to be open to open my mind on this as I speak. If it's a situation, for example, where the supervisor is not empowered to take such action because her employer perhaps facilitates this type of hostile work environment, which creates a different set of circumstances. So again, I'm trying not to close my mind to it, Mr. Chairman, but I'm thinking that if we are to not disturb the scheme by trying to import the Bahamian clause, which seems to be quite particular and fits within their criminal scheme, then that the simplest way that I can think to suggest that the committee looks at it is by adding the converse to 7.1. And not to say that we need to fully consider it here and now, but that if we come back, consider it in between now and the next meeting, that maybe we can get some guidance on that type of approach.
Mrs. Seeley, thank you, Minister. Mrs. Seeley Brown.
Just to agree and to say, Chair, hence my reason for emphasizing before that it is a criminal offense. and there must be some rationale for incorporating this provision in this manner in the Bahamian legislation. So it would have been useful if we could have, gotten some understanding as to why, because as I'm saying, I'm not seeing it in any other legislation, why this particular provision is here and why they created a criminal offense to deal with it.
So I am inclined to work with examining the possibility of the converse to which Minister Johnson Smith spoke of. Going towards the Bahamian legislation, they might have had their own motive, that they are mischief that they were trying to treat with, which may not necessarily be even part of the discussions that we are trying to capture. So maybe we could possibly look at that converse, Minister, in terms of having that inclusion to what 7.1 would have indicated, and to see if it fits into it or it can address what we have been deliberating on. Ms. Grant?
Yes, Chair. Sorry, just to say, I know we started out considering if maybe I missed it, I'm not sure, if we should define workplace. I'm not sure I caught what the decision was, if at all, on that. Because that's what spawned the discussion into bottom up versus top down.
And I think where we left off, you're going to say something, Minister Johnson Smith?
So you go ahead, Mr. Chairman, please.
I think I know the genesis of our discussion and what it would have triggered, but I think in the final analysis and conclusion, the best way is to examine an amendment to clause 7, given the converse to clause 7.1, that would capture the bottom-up situation.
The work.
So 7.1.
I think.
So 7.1 speaks of the top down. 3 speaks of the parallel. And the only thing that we have not been able to capture based on the discussion is the bottom up. And all the others would have captured the various scenarios. Mrs. Seeley Brown?
So I thought the discussion that was in relation to the definition of workplace is the question that Ms. Grant asked.
Yes.
We're not defining it for obvious reasons.
Right.
Is that the decision, Chair?
Yeah.
Okay.
All right. Can we move on to the next one?
Sorry, I think, Mr. Chairman, I had just wanted to clarify that this was a technical advice as well. I mean, my understanding is that the drafting is broad enough as it is, and that therefore we wouldn't seek to narrow it by using their definition.
Their definition. Agreed.
Right.
Agreed.
Okay, thank you. I think when we look back at the minute, it will be good to be clear on that. Right.
All right. So the next one, Ms. Grant.
Yes, Chair. So the next proposal then would take us to institution, and that proposal was made by Jamaica Land. And they suggested an expansion of the definition for institution by adding private sector businesses. They also urged us to consider adding a section that addresses the possibility of workers of companies or businesses sexually harassing clients.
Chair.
Yes.
Public sector, private sector businesses, wouldn't they, I'm not understanding why they would want to be defined on the institution, bearing in mind the way it is used in the legislation. So that's why when you say private sector businesses, what exactly is meant? Because institutions is used, that the term institution is used in a particular manner in clause. What clause is it again? Right, in clause 8.
That's covered by the employer. Private sector will covered by the employer.
Yeah. Private, because if it's a business, won't it be covered by the employer?
Employer. It would be covered by the employer.
Yes.
In any way, shape, or form.
Yeah. I think, though, Chair, we will have another issue to contend with respect to the definition of institution in relation to schools in paragraph 8. If we say that we move in children to another legislation and creating criminal liability for sexual harassment. So
and we're not doing that.
To keep children over 8.
Or are we going to? Yeah, because it's a ticklish one, Chair, because you may have children who are over 18 years old who are also in schools. So so is it that we defined, we limit the age under which this act would apply, or because if we take out school in its entirety, we may not capture the age for the persons who are not considered children as defined in other legislation. So I think that is a discussion that we need to have, Chair.
So you have in schools students who are over the age of, even over the age of 18.
Yes, Chair, it is possible.
Right. And so this speaks of institutions being college, university, and other places of learning or training, which deals with both public and private institutions.
Right. Correct, Chair.
Minister Johnson-Smith.
Yes, Mr. Chairman, thank you. I am just noting the reference made by Mrs. Seeley Brown just now regarding limiting the scope. Is it that you're proposing that what we would do is indicate that this act does not apply to any person under 18?
We can do whatever age we is determined, Chair. Yes, rather than remove schools so that we don't cover, children.
Right, because you would want to keep the educational institution.
Yes.
They're broad.
Right.
You have the teacher, student, etc., and you also have students who are adults.
Yes.
The question is whether we put it at the age of consent, or we put it at the age of majority.
Correct.
Yes. So I would have to take guidance on that or do some research. I'm not, but I do feel that would be a better approach than removing them entirely. And then we have to ensure, of course, and that the committee would have to recommend quite clearly that we expect the matter of minors or persons under the age of 16, wherever we place it, that those should be dealt with by amendments, relevant amendments to the Sexual Offences Act or the Offences Against the Persons Act or Child Care and Protection.
Yes, Chair, and just to add to Chair to that, makes paragraph C, because paragraph C speaks of place of safety within the meaning of sections of the Child Care and Protection Act or any other place for the custody of minors. So you'll have to take out that provision too, Chair.
So that would have to include a separate clause to treat with that the age limit Yeah, Mrs. Seeley Brown, you're mute.
Sorry, Chair, that can be considered, but I think C will have to come out in its entirety.
Yeah, yeah.
So I just want the committee to note that too, Chair.
Sorry, this is which clause? Which clause?
It will be in, on page 2, the definition of institution, Senator Johnson Smith, paragraph C.
Okay.
Because you see, it was speaking to children under the who are deemed to be in need of care and protection. That it was contemplated.
No, but a place of safety is still a place where you have employer-employee relationships, worker-worker. Is it that this was only listed so that the wards could be protected?
Yes, because it is because the sexual harassment in relation to an institution is dealt with separately from sexual harassment at the workplace. So those workers will be captured under the under clause 7, and the institution provision was meant to protect, as you said, the children, the young people at college, these persons who are in these places of safety and that sort of thing.
But remember, in a place of safety, you still have persons in transition. You have young people who are in transition from 18 to 23, or they're wards of the state at they're different stages. They're in different stages of vulnerability. So I'm not sure if we take it out.
Or tweak it.
Yes, would it not be adjusted by virtue of the fact that if it's a place of safety, the issue may not so much be that they are another place for the custody of minors, but the place of safety itself.
It is the inclusion of Child Care and Protection Act.
Take off the custody of minors.
Or any other place for the custody of minors.
Mm-hmm. So I think we can ask the technical team to review that, Mr. Chairman, review how they would define it in the context, if the committee's mind is to deal with children criminally, and note it that it's a decision that we have to take, whether what we would do is scope the act for 18 and over or 16 and over, because that would, I think, determine, it would impact on how they frame the provision.
Ms. Grant?
Yes, Chair, just to say on the issue that Senator Johnson Smith brought up about the age of consent versus the age of majority, I think it would be good precedent to follow similar prescription regarding the age as is covered in the Sexual Offences Act, where it deals with the age of consent. So if we're saying, because the thread of the argument has been that children cannot consent, and that's why they should be protected, because they don't have the capacity to consent and so on. So then if that's what we're saying, then if we're going to define who would be covered in terms of schools, then I think we should take it from the age of consent and not from the age of consent feeding into the age of majority, but it's definitely to have the starting point at the age of consent.
Committee members?
Well, Chairman, my concern is always that there's a difference between the age of consent and the age of the child. You know, there's where does the 17-year-old fall? Age of consent is 16, age of child is defined as 18. So it's always a point of conflict for me. So I'll go with whatever the majority decides.
Chair?
Yes, Member Siblings.
In light of the fact that our concern was can a child consent, I would concur with Ms. Grant with the age of consent.
Okay. Mr. Johnson Smith, your hand is. Any final word on this?
Forgot to take it down. No, I will look to see what the draft comes out at.
Comes with. Okay.
Yes, certainly putting it at the age of consent would address Senator Longmore's concern, legitimate concern regarding the 17-year-olds. And there's also the issue of ensuring that, I don't know, I still have a, you know, I'll wait to see how the draft comes out. I'll wait to see how the draft comes out.
All right.
We're looking at capacity as well.
Yep.
Ms. Grant,
Mm-hmm.
we can move to the next one then.
Yes, Chair. So, okay, so just to make sure that I got what the committee said, the suggestion by Jamaica lands that private sector organizations included in institution, that's a definite no-no.
Right.
Okay, all right. So Jamaica Aid Support for Life said that the word written, they are proposing that the word written be included in the definition of sexual advance, rationale being that it would capture any perpetrator who may choose to harass an individual through letters or any other form of written communication.
Wouldn't C capture that? Wouldn't E? Well, C. I don't know. Maybe the technical team. Mrs. C.D. Brown. Solgen.
It's covered in subclause 2, Chair, of that provision.
That's B?
No, 2.2. 2.2.
2.2.
Yes. But yeah.
Any reference to conduct
Any
of a sexual
reference to this
nature?
act here includes a reference to making it whether in orally or in writing. But I have another question, 2 other points I want to raise when you finish, Chair.
Any reference in this act to conduct of a sexual nature in relation to the person include reference to the making, to or in presence of the person, of a statement of sexual nature concerning that person, whether the state, oh, okay, yes. All right, your 2 other comments?
Yes, Chair. I remember I don't know if it was when we were in the Joint Select Committee meetings before we went virtually. A point was made in relation to paragraph A, when we had a whole issue of persons confusing sexual harassment with sexual assault. And when you look at the definition of sexual advance in paragraph A, it speaks of physical contact. And I think that is where some of the confusion was coming from in relation, because that a sexual assault involves some form of a physical contact. And I had circled it in my draft to come back to, because I think the committee had noted it, and I don't know if we were supposed to have a discussion on it, or we were going to amend paragraph A to take out the whole aspect of contact, which puts it into, it can be taken to be a sexual offense rather than sexual harassment. So I just wanted the committee to address its mind to that paragraph, Chair.
So once you touch.
Well, that was, I think that was creating some confusion in relation to whether or not the whole thing about it being a criminal offense and it being sexual assault rather than sexual harassment. Because if you note, Chet, sexual advance is used in the definition of sexual harassment. It says the making of any unwelcome sexual advance towards a person, and sexual advance includes physical contact in the definition. So I'm suggesting if maybe we should take out the whole physical contact out of paragraph 8, so it is clear that we're not dealing with a sexual offense, because I think that is where the confusion was, Chair. That's the first point, Chair. The second point is, if we are going the way that we are proposing with respect to children, and removing them from this legislation? Is it that we're making a consequential amendment to the relevant statute in this act now so that they can be covered when this legislation is passed? Because then we're going to have a problem where that age group is going to be left, they're going to be unprotected when it comes
They're
to
going to be exposed.
harassment. Yes. So is it that
going to be
we are
exposed.
proposing that's a consequential amendment we made to whatever relevant legislation at this time?
I agree with that, because that would capture any exposure that would have been left as a result of this legislation. And so if we are seeing it now, let's deal with it. Well, Mrs. Seeley Brown, let's go back to, so we can agree on that in proposing the consequential amendments. But I want to go back to sexual advance and where it included physical contact of a sexual nature.
Yes, Chair.
Because in cases that would have been presented, the allegations amounted to physical contact, touching, groping.
That's a criminal offense. So that's a problem, Chair. That's really and truly. And I think that is where, even with some of the presentations that were made, that was the issue. If we're saying that it attracts civil liability and we're dealing with sexual harassment, why are we including the whole issue of physical contact of a sexual nature in this act when the offense of sexual assault, what's the offense called? I'm looking for it, Chair, as I speak to the offense of
indecent assault.
Indecent assault, yes.
Okay.
It's just, I'm just throwing it out, Chair, to see if we are going to leave it here as is, or if we should amend it to not create that confusion that it seems to be creating, because it speaks of physical contact of a sexual nature.
I mean, a number of things come to my mind in terms of, first of all, if it happens and the route that you take in treating with it as a remedy. So if it goes to that route of now it becoming a criminal offense, it may mean pursuing through a different jurisdiction. And would the victims at this stage want to pursue that particular route in treating with it? Because in my mind, this is prescribing an internal mechanism in addressing the matter in the first instance. You get what I'm saying?
I'm not saying that it can't stitch it. I'm just highlighting the confusion that was created. I don't know if any other member of the technical team recall that, because I have it circled and I have a note that it was creating some confusion amongst the persons who would have presented before the committee, because it spoke of physical contact of a sexual nature, and in that instance they were wondering if it should really be a criminal offense and not just attach civil liability. How do we separate that from indecent assault, for instance, in the Sexual Offences Act? So I'm just.
But this is one where the policy decision would have to be taken in terms of the approach. In the first instance, what was the intent when we indicated as part of the definition? What was the real intent? Yes, Minister Johnson-Smith, your hand is up.
Yes, Mr. Chairman, sorry, but I don't have an answer for your question. My thinking is that really it's there because you wouldn't have wanted to exclude it, because it is one of the more obvious ways in which sexual harassment can take place. So it would be a little bit
it's the most prevalent.
Yes, it would be anomalous if somebody were to try and come and rub down my hip every day. And then I could not define it as harassment, because when that is what is manifesting itself in the office.
Yeah.
But the question is, if there's no criminal recourse here, so I'm required to have the police make a charge if that's how I want to proceed. Is it that it's now my choice? I can bring the action here before the tribunal to seek compensation and to seek, redress, because my employer did not prevent that person from harassing me in this manner. Or I could decide to take it to report it to the police that I am the victim of indecent assault. I mean, the truth is that many people won't go to the police to get something like this done, and it'll take some time before this type of treatment, women feel sufficiently confident in the system to actually start to bring these cases. I think that they're more likely to bring these cases where the physical action is manifest, because it's more provable, I think, but or more likely to drive them to need to do it, to make the report. So I would be very hesitant to remove it, and would rather treat it as a matter of sensitization. That is to say that to explain to the public that this does not remove your right to take criminal action if you feel you have been assaulted. Meaning if it's not beyond the technical definition of assault, of course, once there's physical contact, then, and it's unwelcome, then it would be assault. But if you feel the need to take a criminal recourse, then that's there, not necessarily under this act. But if you feel that the type of how it's manifesting in your workplace or in the institution, etc., it's more appropriate for you to seek redress before the tribunal, then you would want that option to be here. And the matter would be one of having persons understand what their recourse is under the act or otherwise, and what employers need to understand about what's appropriate and not in the workplace, or what workers rather to understand about what's appropriate in a workplace.
So I agree with you. Given the number of cases that have presented themselves, this is a primary cause, and so removing it may very well limit the chances of persons raising it as an issue and having it dealt with as part of the internal mechanism. And if we are encouraging it to come forward, we understand the challenges in going through the courts, and the fact that you may face question of confidence in terms of going the route of the police to treat with the matter. So I'm one for agreeing for it to remain as is, and as part of the education campaign, we indicate that this is one of the avenues. You still have others to choose from. Mrs. Seeley Brown?
Sorry, Chair. I would just want to invite the ministry to look at the definition of sexual harassment in the Prevention of Discrimination Act of Guyana, and the manner in which sexual advances is defined in the Protection Against Sexual Harassment Act in Belize, where it doesn't speak of any physical contact, which may create that confusion. It just speaks of conduct of a sexual nature, which is unwelcome, undesirable, or offensive to the person to whom that conduct is directed. So it doesn't go into the long definition that we give here of sexual advance, to speak to physical contact of a sexual nature, which is creating that problem, but it's still covered. It would still capture everything that we have here much more succinctly. Conduct of a sexual nature which is unwelcome, undesirable, or offensive to the person to whom that conduct is directed.
So making it broad would capture
Without
all of
speaking
these.
Yes, yes. So you have
And then, have them both right now. So what are the sections now?
Right, so it's under the Protection Against Sexual Harassment Act of Belize.
Right.
The Belize defines not sexual advances, but unwelcome sexual advances, which means conduct of a sexual nature, which is unwelcome, undesirable, or offensive to the person to whom that conduct is directed.
That's in 2?
Yes.
Okay.
Yes, yes.
But of course, because we define sexual harassment as unwelcome sexual advance, we would just make that little adjustment.
Yes, so Senator Johnson Smith will have to do some tweaking. That's why I was suggesting that we look at how it's defined in Guyana under the Prevention of Discrimination Act, Miss Grant. Of course, we'll have to tweak the language. Yes, so it creates a wider definition.
So what you would suggest then, Mrs. Seeley Brown, is like these examples that are here, you would use them as some sort of guidelines for education. You would take them out of the act, but be telling people in a code of conduct, etc., that these types of things can be understood to be conduct.
Exactly. These things, Senator Johnson Smith, we can actually put this in that code of conduct in the schedule that we were speaking of. And I think that would help.
And that would give greater clarity in terms of the examples that can be cited.
Yes.
And maybe that's where it belongs. Member Siblings?
Okay, Chair. My question has been answered.
So all you had to do was to raise your hand and you get your answer. You got your questions answered.
Yes, but Chair, I know we've been having a good discussion, very fruitful, and we have reached very far. But is this a convenient time? As we lose our quorum?
No, I think so. I think so. I just wanted to conclude this particular point and then indicate to the team that we would have worked very efficiently in terms of our deliberations this afternoon. What those issues are that would have pointed out for review to come back for the next meeting. And Ms. Mack, the next meeting would be
next Wednesday. I sent
next Wednesday.
Email proposing next Wednesday, but I only got responses from 3 persons. Yes, sir.
Well, maybe the persons were very much busy today, but I suspect that based on where we are now, I think we have covered a lot of ground.
Yes.
Good work by the committee and the technical team. And we're in the last lap.
Yes.
So come Wednesday, if we all agree, we
Mr.
can,
Chair.
yes, Minister Johnson Smith.
No, I'm just saying I agree. So I agree. I had meant to send off the consent, but I forgot. So yes, I agree.
Minister Johnson Smith, how you get your hand to raise with your complexion? Tell me how to do that and I will try. This is Seeley Brown.
You gotta have skills.
Tell you.
Mr. Chairman, skills.
My hand should be down, Chair. I'm sorry.
Oh, okay. Okay. So colleagues, at this point, we can conclude the discussions for today and we'll resume next Wednesday. The Minister Grange, if you're still listening in, I know you had asked for 10 minutes. But we weren't able to deliver. So thank you, colleagues. And a motion for adjournment.
I so move.
Seconded.
All right, thank you. Please stay safe.
Thank you, Mr. Chairman. Same to everyone. Same to everyone. And thank you for doing such an excellent job.
Thanks.
Hi, I'm Eliana Charles, and I'm here with my father, Pernell Charles, and today we will be planting a guava tree.
And that's our favorite fruit, and we got this tree from the forestry department. So let's get it done. Some of the tools you need when planting a tree